Yes, madam.
Lordship, we have instruction to appear on behalf of respondent husband. Kindly some time be given to file our wakalatnama. It may be taken on Friday or next Monday.
This is for motion, my lord. So I pray that notice may be issued, let them appear. I do not have objection. And my lord, only prayer, my lord, further proceeding may be stated.
So the distance between Sabua and Tinsukia is lesser than Dibrugarh.
Yes, my lord.
So it would be convenient for you also.
Yes, my lord. It will. And my lord, the
I'm
husband.
not in the case, Lordship. I just have instruction to
And my lord,
take some
husband
time
works
on.
as Sadhya, my lord.
Okay, heard Mr. A.K. Gupta, learned counsel for the petitioner, and madam,
Ditul Das, on behalf of Ditul Das.
learned counsel appearing on behalf of Mr. D.
Ditul
Das,
Das, yes.
learned counsel for the respondent. This petition under section 24 of the Code of Civil Procedure is referred by the petitioner, namely referred by the petitioner for transferring of title suit within bracket D number 116 of 2024 from the Court of Learned Additional District Judge within bracket FTC Dibrugarh to the Court of Learned District Judge Tinsukia, Assam. Mr. Gupta, learned counsel for the petitioner, submits that the petitioner is residing at Tinsukia,
Dumduma in the
Okay.
Tinsukia district, my lord.
at Dumduma in the Tinsukia district, and the respondent is residing at Sabua, Dibrugarh, and that two other cases are pending between them in the court of
My lord, one case is pending, my lord, in the court of the district judge at Tinsukia, my lord.
Learned District Judge at Tinsukia, and another case is pending at the court of
My lord, two
Dibrugarh.
cases. One is at Dibrugarh and one is at Tinsukia, both for dissolution of marriage.
And another case means this case
This case, my
116,
lord, which I want
and
transfer.
the present case is pending the court of Learned District Judge at Dibrugarh. And that the distance between the Tinsukia court and Sabua, where the respondent is residing, is nearer than the court at Dibrugarh. And as such, in the interest of both the parties, this title of D number 116 of 2024 is required to be transferred to the Court of Learned District Judge at Tinsukia. The submission of Mr. Gupta, learned counsel for the petitioner, needs further consideration. At this stage, notice be issued to the respondent. Returnable on Friday.
Yes, Friday or Monday.
However, no formal notice is required to be issued since it's so appears on behalf of Mr. Ditas, learned counsel for the respondent. However, the requisite copy of the petition will be furnished to her during the course of the day. Place the matter on Friday. Interim period will be considered on that Friday.
21 feet. Item number 2.
Lordship.
May I pray that lordship may stay there because Friday he sees paying time for filing wakalat number. Since lordship has issued already notice, my lord.
Lordship, let my senior appear. I have no. I think matter be taken that day only.
Okay.
Item number 2.
May I please your lordship? Lordship is an application praying for transfer from District Judge Sibsagar to Principal Judge Silchar. Lordship, the marriage of the petitioner and the respondent took place at Guwahati. The petitioner is residing at the flat owned by the respondent where the parties last resided together. So therefore, Lordship, the District Judge Sibsagar does not have any jurisdiction to try the petition filed for dissolution of marriage.
Where the case is pending
Sipsagar,
and you want to get it transferred to
Silchar.
Silchar. Why?
Lordship, the petitioner does not have any source of income and it is very difficult for her to travel.
Where the petitioner is residing presently?
The petitioner is residing at Silchar.
Silchar. And what is this? The case is pending.
Lordship, the next date is fixed on 13/4 for written statement, but we have, on the last occasion, we have taken adjournment.
Oh, filing a detained state.
Yes, Lord.
Pardon me, your good name, please.
SS Bora.
Learned Counsel for the petitioner. This petition under section 34 of the Code of Civil Procedure is preferred by the petitioner for transferring of ES, which became temp number 10 of 2025 from the Court of Learned District of Sipsagar to the Court of Learned Principal Kasar Silchar. The Learned Counsel for the petitioner submits that the petitioner is residing at Silchar and she has no source of income. And when the respondent herein has instituted present proceeding before the Court of Learned District Judge at Sipsagar. And that it is difficult on the part of the petitioner to contest the titles of temp number 10 of 2025 in the Court of Learned District Judge Sipsagar, and therefore it is right to transfer the aforementioned titles from the Court of Learned Civil Learned District Judge Sipsagar to the Court of Learned District Judge Silchar. To the Learned Principal Judge Family Court Kasar at Silchar. Let notice be issued to the respondent returnable name for which step be taken by registered for with AD and also by the public.
Your Lordship may kindly stay the title suit proceeding till further.
And considering the submission of Learned Counsel for the petitioner, till returnable debt, further proceeding of PS number 10 of 2025 stands taken. Raise the matter after 4 weeks.
Obliged, Lordship.
Item 3,
May I please, Your Lordship? Your Lordship, it is a transfer petition filed for transfer of a title to TS 6324 from Morigao to Guwahati, Your Lordship. Your Lordship, prior to filing of this title suit by the opposite party, the petitioner has filed a maintenance case before the Principal Judge Family Court, and the case is still pending before the Principal Judge Family Court, Your Lordship. And in that case, the opposite party has been duly representing, and he has filed his WS as well as assets and liabilities.
Pardon me, your good name, please.
Jyoti Kumari Jaiswara, Your Lordship.
Learned Counsel for the petitioner. In this petition under section 24 of the Code of Civil Procedure, read section 151 of the Code of Civil Procedure, read article 227 of the Constitution of India, the petitioner has right for transferring of ES certificate D number 63 of 2024 from the Court of Learned District Judge Morigao to the Court of Principal Judge Family Court at Guwahati, where the petitioner is presently residing.
Guwahati, Your Lordship.
Guwahati.
Yes.
The Learned Counsel
She is a
for the
single mother, Your Lordship.
submits that the petitioner is presently residing in Guwahati Then the title suit number ESP number 63 of 2024. Is instituted by the second party, the court of, by the respondent opposite party in the court of learned district of Morgan. And it is difficult on the part of the petitioner to attend the court of learned district judge Morgan is updated, and as such it is right for transferring the appointment of proceeding from the court of learned district judge Morgan to the court of learned principal judge family court at one. That notice be issued to the respondent returnable in for which step be taken by registered court AD and also by the process. That what is this the case is pending now?
Sorry, your lordship,
That what is this the case is pending?
it for WS.
WS.
for WS. Your lordship, the matter may be stayed till the next date.
Considering the submission of learned counsel for the petitioner till returnable that further proceeding of title. So D number 63 of 2024 stands state. List of the courts.
Item 4,
Are you,
May it please the Lordship. Well, as a revision under against page 24 order, dismissing my 151 application, seeking restoration of the suit purportedly under Order 9, Rule 5. Now, may I just indicate the fact, my Lord? Initially, I filed a money suit in 2014 before the Civil Judge Senior Division 1. My Lord,
That which place?
Guwahati, my Lord. Kamrup, Guwahati. my Lord. Following service of summons, my lord, defendant appeared, filed his WS, issues were also struck. Then I tendered my evidence on affidavit. Then the matter was referred to, my lord, advocate commissioners to complete this cross-examination. At that stage, my lord, this matter stood transferred to Civil Judge Junior Division 1 in view of amendment to the Civil Acts, my lord, enhancing the jurisdiction of the civil courts. So, court summons was issued. It was returned back, saying that he was not found in the address. Then we are told to find his address and take summons, take steps. Then on last occasion, my lord, was fixed on 16/5. At that day, we filed an application, my lord, seeking just one last chance to take steps and to figure out his new address, my lord, because we have information about his whereabouts and we're just trying to cross-check that. That application was rejected by page 16 order, my lord. Can you see page 16 order? And the suit came to be dismissed. Is put up before me, so-and-so on leave. So-and-so has filed a bearing petition for last chance taking steps. Upon perusal of the case record, it is seen the plaintiff was directed to take steps on so-and-so and on subsequent dates. On 3/5/24, the plaintiff was given last opportunity to take steps, but no steps has taken till date. Therefore, the petition bearing so-and-so stands rejected. So this application, my lord, this order was purportedly issued under Order 9, Rule 5. Kindly see Order 9, Rule 5, my lord. For a moment.
Whether this petition, bearing number 379 of 2024 is part of the record?
It is not part of the report. And I have it, I can show it to the court, my lord. Admittedly, my lord, an application was filed seeking a last chance because we figure out his
No, that's
whereabouts.
all right, but
My lord,
is it not necessary to go through that petition or what are the grounds you have taken therein?
no, fact is, my lord, this application was rejected, rightly or wrongly. I'm not on that. If application was rejected and this order was, my lord, purportedly issued under Order 9, Rule 5, because I failed to take fresh steps after return of summons. Then we filed this page 17 application, seeking restoration under 151. Can you see page 17 order application? 151 file because there is no specific provision in the code seeking restoration under of a suit dismissed under Order 9, Rule 5. And here a judgment, my lord, laying down the proposition that 151 application is maintainable. Again, dismissal of order under Order 9, Rule 5.
So it,
Yes. Before that, kindly see this, my lord, dismissal order, kindly. Page 24 order, man.
I have gone through it.
Okay. The full bench judgment of the Bombay High Court. Can you see para 13, 1-3. Last page, man, para 13. Noting that there is no express prohibition in the court for a suit dismissed under order sub-rule 1 of rule 5 of order 9 of the court to be restored, we hold that in such situation, inherent power under sense so-and-so would be available.
But in the impugn order, there is no reference to rule 5 of order 9.
Absolutely no, my lord. Kindly see, it was invoked 122.
Yes.
It was dismissed on the ground that it is barred by limitation. This order was passed, my lord, page 24, primarily on the ground that this application was barred by limitation. And it invoked 122, article 122. 122 on the face of it has no application. Kindly see 122, article 122.
Yes.
I'm just. When it applies, it says when a suit, appeal or application for review is dismissed for default of appearance, for want of prosecution, for failure to pay cost of service or process, or to furnish security for cost. This order is under order 9 rule 5. It is not covered by article 122. It is apparently wrong, my lord. In fact, my lord, when we file this application, my lord, we make a prayer to put up with the case record so that we can file legal arguments in support of this application. It was not even put up with the case record. The court so modo took it of his own without hearing us and then came up with this dismissal order, page 24. Can you see this? Page 17. There is nothing that is put up with the case record. Register petition as missed case, so and so. Page 17 is on the body of this petition. My lord will find register the petition as missed case. We are not hard.
So you have not been heard while passing the order.
No. No whisper that this application was filed under 151. In the impugn order, my lord.
Oh, we set aside the matter and remand it to the
Yes.
trial court.
Yes,
Consider your application
yes,
after affording an opportunity of.
yes,
heard.
absolutely. That's my prayer, my lord. That's all my prayer is.
Heard, means I am not learned counsel for them. It is petition under Article 227 of the Constitution of India, read with section 115 of the Code of Civil Procedure. The petitioner, namely Utpal Talukdar, has challenged the order dated 21/12/2024 passed by the learned civil judge junior division number 4, Kamrup M. In his case number 595 of 2024, arising out of MS number 258 of 2020. It is to be noted here that by the impugn order dated so and so, the learned trial court has rejected the application filed by the petitioner under section 151 CPC for restoration of the suit purportedly dismissed under order 9 Rule 5 of the Code of Civil Procedure. Mr. Nath learned counsel for the petitioner submits that the petitioner as plaintiff had instituted one money suit before the learned civil judge, senior division, number 1. For recovery of a sum of rupees 3,50,000. In the said money suit, the defendant, the respondent herein entered appearance and submitted his written statement. And subsequently, the suit stood transferred to the Court of Learned Civil Judge, Junior Division number
1. Sorry, 4, man.
number 4, paragraph 10. Due to amendment of the Bengal, Agra, and Assam Civil Court Amendment Act 2020, by which pecuniary jurisdiction of civil courts in Assam has been raised. Thereafter, the learned civil judge junior division number 4 has issued notice to the respondent stroke defendant to his address provided in the plaint. But the said notice returned unserved, and the addressee was found not present in the address. Thereafter, the learned trial court has directed the petitioner to provide the proper change address of the respondent stroke defendant. The petitioner visited Surat on number of occasions but could not collect the address of the respondent stroke defendant. Thereafter, the suit was posted on 13/5/2024 for service report, and on that day, the petitioner has prepared on application for granting more time to furnish the address of the respondent stroke defendant, and the same was allowed by the learned trial court. Thereafter, on 16/5/2024, the petitioner has filed another application seeking one last chance to furnish the address of the respondent stroke defendant. But the learned trial court has dismissed the petition and also dismissed the suit purportedly under Order 9, Rule 5 of the CPC. Mr. Nath further submits that the learned trial court has dismissed the petition referring to Article 122 of the Limitation Act 1963, but the said article has no application in the present case. Apparently, the order ought to have been passed under Order 9, Rule 5 of the Code of Civil Procedure. Then further, Mr. Nath submits that while the petitioner has filed the application under Section 151 of the Code of Civil Procedure before the learned trial court for recalling the order dated 16/5/2024, the learned trial court has directed the same to be registered as Ms. J case. But while passing the order on 21/12/2024, the learned trial court has made no reference to the aforementioned petition. And without hearing the petitioner, the impugned order was passed. And as such, the impugned order is arbitrary and illegal, and therefore Mr. Nath consented to set it aside. And remand the matter to the learned trial court to afford an opportunity of being heard to the petitioner and to dispose of the petition number 1804 of 2024. And thereafter to pass necessary order. Having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents present record. And also peruse the Article 122 of the Limitation Act 1963. And it appears that Article 122 is applicable only to restore a suit or appeal or application for review or revision, dismiss for default of appearance, or for want of prosecution, or for failure to pay cost of service of process, or to furnish security for cost. And apparently, the said provision appears to be not applicable in the present case. And as the impugn order is passed without affording an opportunity of being heard to the petitioner, this court is inclined to set aside the same and to remand the matter to the learned trial court to afford an opportunity of being heard to the petitioner and thereafter to dispose of the petition in accordance with law. In terms of above this, CRP is not disposed of at this motion itself.
I'm like,
Item 5.
Wait, please, Ismail. Well, this revision is preferred under Article 227, my lord, against an order whereby my application for framing preliminary objection, my lord, on the ground of jurisdiction was rejected, my lord. I'll just give the gist of the case, my lord. The respondent number 2 filed a complaint against the respondent number 1,
No, Mr. Iqbal,
my lord.
the petition was filed that the industrial tribunal has no jurisdiction to entertain the petition.
My lord.
So is there any specific part?
My lord, the industrial tribunal formed under the state government that has got no jurisdiction, but the central industrial tribunal, my lord, that has got jurisdiction in view of the section 4 of the Industrial Dispute Banking and Insurance Committee Act, my lord. And if that is read with along section 2B1 of the POSH Act 2013, my lord, it is clearly stated that, my lord, that if any banking or insurance company is governed or ruled by the central government or is funded by the central government, then the central government will have a say on any proceedings, my lord. Departmental proceedings or any proceeding under the POSH Act 2015, my lord. I'll just come to that, my lord. My lord, may kindly take section 2B1 of the POSH Act. Sexual harassment of women at workplace, 2013. It is also there in paragraph number 18, my lord. I have quoted para 18 of my petition, my lord. Para 18 at page 16, my lord.
Yes.
For that the learned tribunal bureau, while passing the impugn order dated 31/2025, miserably failed to take notice of the relevant law as contemplated in terms of section 2B1A of the POSH Act, which clearly mentions the term appropriate government. As quoted in the aforesaid subclause A, appropriate government means in relation to a workplace which is established, owned, controlled, or wholly or substantially financed by the funds provided directly or indirectly, A, by the central government or union territory administration, the central government, and B, by the state government, then it is state government. Here, my lord, admittedly is Yes Bank, my lord. It is funded by the RBI. We are guided by the RBI guidelines, my lord. And the central government funds the Yes Bank, my lord. Here, state government has got nothing to say, my lord. Now, the industrial tribunal, that is, they have preferred the appeal under section 18, my lord. That is constituted and instituted under the state government, my lord, not by the central government. That is my first objection. And if my lord comes to paragraph number 15, my lord, there, my lord, section 4 of the Industrial Disputes Banking and Insurance Companies Act is also. If this section 21B is read with section 4, my lord, of the Industrial Disputes Banking and Insurance Company Act 1949. Para 15, my lord, has got. For the learned tribunal, while passing the impugn order dated, miserably failed to take notice of the relevant law as contemplated under Section 4 of the Industrial Disputes, clearly states that notwithstanding anything contained in any other law, it shall not be competent for a state government or any officer or authority subordinate to such government to refer an industrial dispute concerning any banking or insurance company or any matter relating to such dispute to any tribunal or other authority for adjudication, inquiry, or settlement. So, my lord, since it is specifically stated, my lord, that state government will not send or not initiate any proceeding if it is related to a banking company or an insurance company, which is comes under Section 4 as well as Section 2(1)(b) of the POSH Act, my lord. So, the state government or the industrial tribunal formed under the state government will have no say, my lord. It will be the central industrial tribunal which will adjudicate the matter. That is the clear-cut case, my lord, because of which I filed an application under Order 14 Rule 1 and 2 for framing preliminary issue. That was rejected, my lord.
Now, what is your prayer and this?
My limited prayer is that, my lord, the proceeding that is pending before the industrial tribunal, that should be set aside. Let them approach the central industrial tribunal, my lord. I've got nothing to say, my lord. If there is any grievance for them that no natural justice was followed, no inquiry was committed or inquiry was not as per law, let them approach the central industrial tribunal.
Yes, what is your
Lordship.
subject?
Lordships, the learned counsel have not read completely the provisions of Section 2(b), your lordship. So, our lordship may kindly say Section 2(b) of POSH Act.
All right.
I have a copy.
You were referring to section?
Section 2(b),
Yes.
appropriate government means here, lord. In relation to a workplace which is established, owned, controlled, or wholly or substantially financed by funds provided directly or indirectly, A, by the central government or the union territory administration, the central government, by the state government, the state government. Here in this case, your lordship, the admittedly, evidently, the petitioner bank is a private sector bank. It's not, the bank is not funded or established by the RBI or central government, your lordship.
No, but follow the guidelines issued by the RBI.
So all banks are followed by RBI, your lordship. It's a private sector bank. Now your lordship may come clause 2, your lordship. In relation to any workplace not covered under subclause 1 and falling within its territory, the state government. Here, the respondent bank is not established, not controlled, not owned, or financed wholly or substantially by central government. So it's not covered under the definition of Section 2(b)(1), your lordship. So it's fall under the definition of Section 2(b)(2), the state government. Here in this case, the branch is here, so come under the state government authority, your lordship. Here. And further, your lordship, Section 4, the banking industrial disputes, which my learned friend referred.
The bank is controlled by the state government.
Yes. Bank is not controlled by. It's an appropriate, which is appropriate government. In this case, your lordship, the state government is the appropriate government because the workplace is Guwahati, your lordship, in Assam. Is not established by state government. As under definition 2, it's if not fall under the definition of 2(b), then the appropriate, the Section 2(b)(2) will come into play, your lordship. Further, your lordship, my learned friend referred the Section 4 of Industrial Disputes, Banking and Insurance Companies. This act is relates to disputes in relation to banking and insurance. Here in this case, all the dispute, allegation, inquiry was done under the POSH Act. And POS Act Section 18 specifically referred, prescribed for provisions of appeal. So, Industrial Dispute Banking and Insurance Companies Act not applied here. Now, let the matter may be, let to file objection, your lordships, and matter may be fixed for final disposal, your lordships, and no stay may be granted, your lordships. Because at this stage, case is fixed for your lordship for production of document, your lordship.
My lord, whatever objection they had filed, my lord, in the trial court before the industrial time, that will only suffice, my lord. They have extensively written, even given
I have extensively
rejoinder
written.
also, my lord.
Even then, your
They have filed
lordships,
objection,
even then,
rejoinder.
now your lordships, that they have deliberately not brought the order of the tribunal, wherein it was fixed for production of document. Even given sufficient time to production of document.
Hmm.
Next, third, my contention
You
is,
want to file objection?
yes, Lord.
Okay, all right. Let him file objection. We will hear it out.
Till then, my lord,
No,
further
no, no,
proceeding
no,
may be
no,
started.
lordship.
Otherwise, my lord, it
No,
is fixed on
lordship.
next Monday.
No, lordship. It's
If the
not,
proceeding goes ahead, my lord, it will cause a chaos, my lord.
it's fixed for only for production of document.
Caveat would be hard. Caveat search. Heard Mr. Equal Learned Counsel for the petitioner and Mr. Your good name, please.
A. Chaudhuri, your lord.
A.
Chaudhuri.
Chaudhuri, Learned Counsel for the respondent. First petition under Article 227 of the Constitution of India. Read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the correctness or otherwise of the order dated 30/1/2025. Passed by the learned industrial tribunal in a reference case number 3 of 2024. This will include here the fighting order dated 22. The learned tribunal has dismissed the petition filed by the petitioner under order 14 rule Roman 1 and 2, seeking dismissal of the appeal for lack of the receipt. The learned counsel for the respondent submits that he may be granted some time to file objection and the matter will be finally heard. The next week,
Next week, your lordship.
place the matter on Monday.
Lordship,
Let
my,
it be fixed on Tuesday, my lord, on a non-hearing day, my lord.
Tuesday.
lordship, my name has not been reflected. I am for caveat to respond number 1, your lordship.
Respondent number 1.
Respond number 2 is
Your
the
name is
complainant.
reflected already. Your name is reflected.
My lord, till then, further
No,
proceeding may
no,
be
no,
started,
no, lordship.
because it is
No,
fixed
no,
on
no,
Monday.
no, lordship. No,
Parallel
no,
proceedings
no,
are
no, no,
going ahead.
lordship. No, lordship. I am
We'll
serious. about it.
finally decide the matter.
Yes, lord.
My lord,
Yeah,
next Tuesday, my lord.
Tuesday.
Deeply open.
Six.
Wait, please, your lordship. My lord, this is revision against my lord allowing the my lord amend the plate, my lord, that against that order I came before this honorable court, my lord.
But there is a decision of Supreme Court that all amendments should be allowed. Recent decision.
Recently, my lord, all amendment, my lord, the amendment which is related to the, my lord, your lordship kindly see here, my lord, my anxiety, my lord, yes, my lord, you're rightly, my lord, pointed out, yes, and said, your lordship kindly see when, my lord, I made an objection. I'm defendant here, my lord, I'm made an objection that, my lord, that if the amendment is allowed, nature and character of the suit is, my lord, to tell you, my lord, frustrated. That plea, when I have taken a plea, my lord, learned court below should have given a finding on that, my lord. Without giving any finding, simply that it is file on time, that's why it is allowed. Can it be permissible, my lord? All amendment, my lord, here, what happened, my lord, your lordship kindly see it. The suit is for specific purpose of contact. The plaintiff suit is that, my lord, specific purpose of contact, my lord, is that he purchased a plot of land along with a crusher machine, my lord, for consideration of rupees 50 lakhs and 48 lakhs he has been paid. Say that is the plea of the plaintiff, my lord. 48 lakhs has been paid. and 2 lakhs will be paid, and my lord, registered sale will be made. That was the plea of the plaintiff. But in the meantime, the person concerned, my lord, from whose my lord that it was purchased, my lord, he died, my lord, and my father, my lord, he was died. And now we are made a party. After my death of my father died in COVID, my lord. After death of my father, this suit has been instituted, my lord. But our specific plea in the WS that no money has been paid and land is still in my possession. We are continuing, the SR machine is in our name. We are continuing, we are doing all this business. In the plain, my lord, nowhere stated that, my lord, what mode the payment has been made. So either through bank or by cash. Nothing made, my lord. When I taken this plea, now, my lord, the plaintiff tried to amend the plaint, says that no, after institution of it, we are dispossessed, my lord. Now he tried to, my lord, project a case, my lord, as a case of dispossession, my lord. So case of dispossession and case of specific performance, two different things, my lord. And that is, my lord, one aspect. Another aspect is, my lord, he want to, my lord, the plaintiff want to make the respondent number 5, the new respondent to be added in this case, who is, my lord, his son. His son, my lord. That I have no objection, my lord. But from that way, he want to prove it that, my lord, there is another agreement to sell that particular land with my son, my lord. That is also, it will, my lord, it's a completely new story that to write to come. But my main anxiety is that, my lord, when I taking a plea that the specific, my lord, the specific plea that it will be changed the character of the suit, my lord, without giving any finding, that amendment is been allowed. So that is my, even, my lord, that is be, my lord, kept by this honorable court. I have no objection, but that finding has to be required, my lord. Your lordship, kindly see I am the impugn order, my lord.
Page number?
Impugn number, your lordship will find it page number 89. From 89, my lord, as your lordship got it, please, the order that is 7/9/2024. Page 89. From 89 to, my lord, 101 page number, my lord, all are, my lord, submission of the, my lord, plaintiff. From 101 to, your lordship kindly see, 101 to, my lord, 103, these are, my lord, submission of the defendant. Now, my lord, under the approaches circumstances, opposite party paid for dismissal of the suit in the so. Since the petition, your lordship kindly state where goes to 103, page number 103, my lord. Since the petition heard both sides, perusal of the record is seen that the instead connected suit was filed on 27/4/2023, wherever the plaintiff on the basis of the agreement for sale dated 12/2/2021 sought specific performance of contract by the defendant. Further perusal of the record specifically that the reflected that the plaintiff pleaded about the payment of earnest money of amount of rupees 48 lakhs in advance amount out of total sale consideration of rupees 50 lakhs, 50 lakhs one. Along with the consequential taking the possession of the suit land and facing the same instead in causing the machine by construction so. The record shows that the defendant filed their written statement and counterclaim pleaded that regarding their possession over the suit land. The plaintiff in the instant amendment petition asserted about the dispossession of the defendant on 24/6/2023 and also about the discovery of a new document regarding which he has stated they have to previous notice as those who are in possession of the son of Ajay Kumar Chaudhary and Govinda Kumar Chaudhary and also asserted Govinda Kumar Chaudhary has to be implemented in the suit for just proper adjudication. Order 6, Rule 17 of the CRPC lays down the division so. The court may at any stage of the proceeding allow the party to alter the amend his pleading in such manner and such terms and maybe all such amendments shall be made on by necessary for the purpose of determining the real question of the controversy between the parties. Providing that no application for amendments shall be allowed after the trial and commencement unless the court came to the conclusion that in spite of due diligence, the party could not have raised the matter before the section trial. It is clear seen that the provision of the law allowed the parties to amend their pleading at any stage of the proceeding before commencement of the trial. The case record reflected that the statement petition, instead petition filed when the suit is posted for filing of written statement against the counterclaim of the defendant, and such the trial court concerned the suit has not been not commenced yet. Considering the fact and certain the insert of the pleading of the plaintiff is a subsequent development after the filing of the suit, and this trial has not committed, and yes, such so and so, so and so. But where is the finding that, my lord, this that my specific plea that it will change the character and nature of the suit, my lord? There is not a single line, my lord. If, my lord, that I am satisfied, it will not change, my lord, that if there is a finding, that is also, my lord, done, my. But not, here is nothing, my lord. That's why I am before your lordship, my lord. In my written statement, my lord, against the amendment, my lord, I have clearly taken that plea, my lord. Page 84, my lord, para 7. That is short. WS I have filed, my lord.
Let notice go at this stage.
My lord,
We'll stay further.
my lord.
Third, Mr. Mahto, learned senior counsel assisted by Mr. Learned counsel for the petitioner. This petition under Article 237 of the Constitution of India, the petitioner has challenged the order dated 7/9/2024, passed in Ms. case number 19 of 2024, arising out of title suit number 11 of 2023. By the learned civil judge, senior division Golaghat. It's to be noted here that by the review order dated so the learned civil judge senior division Golaghat has allowed the Ms. case number 19 of 2024 filed by the respondent hearing. Mr. Mahto, learned counsel for the petitioner, submits that the respondent herein has instituted a suit for specific performance of the company. And while the suit was pending at the stage of
Stage of, my lord, filing WS against my counterclaim.
filing a written statement against the
Counterclaim by the defendant.
filing a written statement against the counterclaim filed by the present petitioner. The respondent herein filed one petition for petition under order 6 rule
Order
7
6 rule 17, my lord.
with order 1 rule 10 of the Code of Civil
For
Procedure
implement-
for amendment of the plaintiff. And the learned trial court and in the said petition, the petitioner herein has filed objection. By taking a specific plea that if the amendment is allowed, then the nature and character of the suit will be changed. But without considering the objection filed by the petitioner, the learned trial court has allowed the amendment.
Without addressing that issue, my lord.
Without adjudicating the issue raised by the petitioner. Raised by the petitioner. The submission of Mr. Mahto, learned canoe counsel needs further consideration that this is notice fees due to the respondents returnable in 4 weeks that be taken by registered force with AD and also by legal process within a week from today. Until returnable date, the review order dated 7/9/2024 passed in Ms. case number 19 of 2024 arising out of title suit number 11 of 2024 stands state till returnable date. List of records.
Developed. Step by
Item 7,
registered post. My lord.
Notice fees of by registered post with ATN also by usual process within a week.
Developed.
May I please your lordship?
Yes.
Lordship, this instant petition is filed against an impugn order, rejecting the petitioner's prayer to vacate the order to proceed ex parte against him in the suit. Lordship, may I kindly peruse the impugn order at page 39.
But you first tell me whether revision will lie or appeal will lie against the order.
Lordship, revision will lie because it's not
Are you
a-
sure?
Yes, Lordship. I have checked, Lordship. It's not under order 43 rule.
Pardon?
It's not, Lordship, revision will lie. Under Article 227, Lordship.
Under
Article 227, Lordship.
are you sure?
Yes, Lordship, I have checked. It's not an appealable order, Lord.
But there are some decision of
Because
Supreme
it's
Court that
against-
appeal will like.
Order 9, Rule 7.
You
Lordship.
you see, you we will list the matter day after tomorrow. You come prepared.
Okay, Lordship.
List the matter on Wednesday so as to enable the learned counsel for the petition to satisfy this court that revision will lie against the order dated 5/2/2025 passed by the learned civil judge senior division Dorong Maholdo entitled September 10/5/2020. Wednesday, you come prepared.
Lordship, the matter is fixed on 20th of March. 20th of March before the learned trial court. And my WS has not been accepted by the learned court below. Lordship,
Okay.
can it be fixed on 19th, Lordship?
19.
Much obliged, Lord.
Item 8,
Please, your lordship.
Yes.
My lord, this is a petition, my lord, by whom my lord, against the order dated, my lord, 22/3/24, by which, my lord, the learned appellate court, my lord, rejected the prayer for grant of injunction, my lord. The case
Let
is-
notice go.
Yes, my lord. In the meantime, my lord, the status quo may be directed to be maintained between the parties, my lord.
But is there any petition to that effect? No.
There is no separate petition, but the prayers has been made in this petition itself, my lord. At page 26, lordship will find that I made my interim prayers, my lord. So if, my lord, the direction is passed to maintain status quo, everything will suffice, my lord.
Mr. Chowdhury, usually a separate application is filed for granting such a delay.
My lord, because this is a
Because
because this is a revision, my lord,
those principles
my lord.
in granting injunction has to be discussed.
Yes,
And you have to satisfy that there those principles exist.
in my favor, my lord. Well, basically, I am against the legality of this order which has been passed, my lord, because while concluding, my lord, the learned, my lord, appellate judge, my lord, he has come to a finding that despite, my lord, the bar under 154 of the Assam Land and Revenue Regulation, by ignoring the fact that it's a suit for declaration of right title and interest. And, my lord, it is a settled, my lord, legal, my lord, principle now, that when it is a suit for declaration of right title and interest, then, my lord, the bar of 154 of the, my lord, Land Revenue Regulation does not get attracted. So that is the folly he has committed, and he has not taken into account the fact that there is a report from the revenue authorities which says that the land is not in possession of the, my lord, petitioners who had claimed for demarcation, my lord. And in that case, my lord, if your lordship sees the provisions of regulation 23, my lord, the power of the demarcating authority is only, my lord, to give, my lord, to the person who is in possession, nothing beyond that. So when admittedly it was, my lord, delivered, shown before him that the petitioner is not in possession, he ought to have referred the matter to the civil court for adjudication, my lord. And without doing that, my lord, he has taken it upon himself to adjudicate by knowing that, my lord, there is, my lord, no possession. That your lordship may kindly turn to page 67, my lord. At page 66, my lord. Page 66. My lord, that is the report, my lord, of the Mondal, my lord, given to the circle officer. May I read it, my lord?
Yes,
The applicant Shri Bharat Agarwala, son of late Rajkumar Agarwala and Lokhiraj Deka, son of late Horokanto Deka, have submitted an application for the joint measurement of government land in Sinduri Gopa village in Sila Sinduri Moja. The land in question falls under Myadi Pata number so and so and includes DAG number so and so, so and so, so and so, covering a total area of 4.78 R. Lassa. The mentioned land is recorded in the name of Ashok Kumar De, son of late Muninder Chandra De, along with other Patadas in the revenue record. The applicant has acquired the said land from Patadar Sri Ashok De through an unregistered agreement under serial number so and so. Regarding the joint measurement of the said land, the presence of Patadar Ashok De is necessary and should be ensured. Additionally, proper legal procedure must be followed and discipline should be maintained during the process. Therefore, the joint measurement of the mentioned land has been scheduled for so and so. It is noted that present Patadar do not have possession of the land. So they do not have possession, my lord. And if your lordship kindly take up regulation 23, my lord. Regulation 23A, my lord, 1A. May I please, my lord? Of the Assam Land and Revenue Regulation. I may pass over the book, my lord.
yes, you are referring to?
To the regulation 23, my lord, of the Assam Land and Revenue Regulation.
Yes,
My lord. Procedure in case of boundary disputes. The chapter is survey and demarcation of land, my lord. Whether in the course of survey it comes to the knowledge of the survey officer that any boundary dispute exists, he shall notify the same to the settlement officer who shall proceed as follows. If the dispute is between the proprietors of different estates, the settlement officer shall decide it on the basis of actual possession, or if he is unable to satisfy himself as to which party is in possession, he may determine by summary inquiry who is the person best entitled to possession and may put him in possession, or he may refer the dispute to arbitration for decision on merits, so and so, so and so, so and so. So, my lord, primarily the authority of the, my lord, regarding demarcation, the authority is to see who is in possession, my lord. And if it is somebody is in possession, then he will see, my lord, whether there is a rightful possession or not. My lord, now my possession
Mr.
is,
Chaudhary, going by the this page number 66,
my lord.
where it is mentioned that he is in possession.
No, but the petitioners are, these persons are the respondents, my lord. In page number 66, these people, the applicants, my lord, they are the respondents in this case, my lord, and defendants in the suit who have sought for demarcation, my lord. And in this report, it is stated that they are not in possession. These are the applicants who are not in possession, my lord. That is why when they are not in possession, my lord, it is admitted that somebody else is in possession. So, my lord, this revenue officer, my lord, he cannot, my lord, exercise his authority. And the finding, my lord, of the learned court below that, my lord, there is a bar, my lord, under 154. It also cannot be accepted because of the fact that if your lordship sees, my lord, the title suit, it is a suit for declaration of right title and interest, along with, my lord, other reliefs, my lord, which has been claimed, my lord. Lordships may kindly see page 103, my lord.
100
Page 104. Page 104, bottom, my lord, on the right-hand column. A suit for declaration of right title and interest, confirmation of possession, cancellation of field mutation, entry, so and so, so and so, so and so. So this was my case, my lord. And if this is a case where I have sought for declaration of right title and interest, my lord, then the bar under section 154 of the Assam Land and Revenue Regulation will not apply, my lord. It is a settled legal position, my lord. That, my lord, at the end of, my lord, 154, lordship will find the commentaries also, my lord. It has been held by this court, my lord, in the case of Tuniram Kotoni, that the provisions of the section 154 of the code does not debar the civil court from entertaining declarative suit of title. That is, my lord, 2004, volume 3 GLR, page 641.
Sir, we will consider your impairment here on next set.
My lord, until that time, my lord, if the demarcation proceedings are forcefully initiated and my lord, my lands are taken away, then ultimately, my lord, the suit will become infructuous, my lord. Because lordship will kindly see, my lord, in the records, there is also an FIR, my lord, which I had filed because, my lord, the lands were sought to be taken away forcefully, my lord.
Heard Mr. G. Chaudhary, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the judgment dated 22nd of March 2024, passed by the learned district judge Kamru Amito, is appeal number 1 of 2019. It is to be noted here that by declaring judgment dated so the learned district judge Kamru Amito has upheld the order dated 3/10/2019 and 21/10/2019 passed by the learned civil judge Kamru Amito in case number 142 of 2019, filed by the petitioner, Appellate, right for grant of ad interim injunction in connection with case number 116 of 2019. Files the petition and the grounds mentioned therein, and also files the interim judgment passed by the learned district judge on 22nd of March 2023 in case appeal number 1 of 2019. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by the process we can come to that. Mr. Sotori, learned counsel for the petitioner submits that there is a requirement for ordering the parties to maintain status quo. And unless such an order is passed, then the respondent herein will, whether they have initiated any action.
That is still going on, my lord. The demarcation case is going on, my lord. Because, my lord, that this stay order was vacated, my lord. There was no injunction. They have again initiated that proceeding, my lord.
Till now, it has not been initiated.
No, my lord. Till the vacation of this order, it was kept under abeyance because since 2019, this injunction was continuing. On, my lord, this date it was vacated. Thereafter, my lord, they have taken up.
And unless the parties are directed to maintain status quo, this revision petition would be infructuous, and therefore it is intended to issue such direction to the parties to maintain status quo. But having considered the submission of Mr. Chaudhary, learned counsel for the petition, and also considering the facts and circumstances of the court, it is provided that status quo is as on
Today,
shall be maintained till returnable date,
my lord,
list after 4 weeks.
my lord. I am diplomat.
Item 9.
Lordship be taken up after some time as senior is on legs.
Item 42, bail hearing. Boson.
May I please, Your Lordship. Item 15, 42, and 44, Your Lordship, may kindly taken together, Your Lordship. Same incident, Your Lordship, 2 FIR was lost, Your Lordship.
Yes, Mr. Das, you have received the instruction.
Lordship. They have not submitted in the court, Lordship, on 12/2/2025, Lordship. As far they have given us a charge sheet, Lordship, on that date is written there 12/2/2025. And it is in that,
No, now you directly tell me whether charge sheet was filed within the stipulated period of 60 days or not.
Lordship, in the submitted in the court, Lordship, they have submitted this charge sheet on 27, Lordship. And if Lordship want to
27.
on as far it is written in the 27/2, Lordship, but they have not stated confirm the Lordship. But on not submitted on 12/2, as the date is there, Lordship, in the charge sheet, that it is on 12/2/2025. I have asked them when you have submitted before the court, Lordship. They did not confirm it to me.
And it was put up before the court on which date?
Lordship, they have not confirmed me on that count, Lordship.
No,
Lordship. But if I look
in
into
the charge sheet, it is written as 28.
2020, they have stated that it is by mistake, they have written it 2012, 22/2025. It needs to be 12/2/2025, Lordship. They stated only that thing to me, Lord.
No, if we count the 28/12/2025 is the date of submission of charge sheet,
Lordship.
then whether it would be within the period of 60 days or beyond the period of 60 days.
Beyond the period of 16 days.
Beyond.
Beyond.
67 days at that time.
Heard Mr. A.R. Corin, learned counsel for the accused, and also heard Mr. K.K. Das, learned additional PP for the status complaint. This application under section 483 of the BNSS is prepared by the accused, Tandur Haq and Sanidul Islam, who are languishing in Delhi in connection with Support PS case number 198 of 2024 under section 61(2), 19(3), 132, 121(2), 121(1), 109, 76 of BNS. Is to be noted here that above noted case has been registered on the basis of an FIR lodged by SIP Kantan Jyoti Chaudhary of Support PS on 15/12/2024. The learned counsel for the accused submits that both the accused were arrested on 15/12/2024, and since then they are languishing in jail for more than 60 days. Further, Mr. Corin submits that after completion of investigation, the IO laid charge sheet before the learned trial court. And the trial court on 20th/2/2025, which can be inferred from the date put by the officer in charge in the charge sheet, though in the column number 2 of the said charge sheet, the IO has mentioned the date of filing the charge sheet as 12/2/2025. If the date put by the officer in charge in the last column of the charge sheet is accepted as the correct date of filing the charge sheet, then in the meantime, the statutory period of detention already elapsed. And the charge sheet having not been filed within the stipulated period, the accused here in this case are entitled to default bail. And accordingly, it is provided that on furnishing a bond of rupees 50,000 each with one security of like amount to the satisfaction of the arresting, to the satisfaction of the learned trial court, the accused person shall be enlarged on bail.
MFC. Subsequently, it is renumbered as PRC case number 128/25. Before JMFC eligible. Item 15, Your Lordship. In CD received, Your Lordship. CD
CD is received.
Item 15,
CD received.
In 15, item number 15, CD received, Lord.
Total 92 days, Your Lordship. Mandatory is over, Your Lordship. 2 days.
charge sheet not submitted.
Submit,
CD in High Court,
CD is not.
not submitted.
Heard Mr. Corem, learned counsel for the petitioner, for the accused, and also heard Mr. K.K. Das, learned additional PP for the state respondent. This application under section 483 of the BNSS is deferred by accused Ayub Ali, who has been languishing in jail in connection with Chopper PS case number 199 of 2024 under section 25, which is bracket 1, capital A of the Arms Act. Corresponding to GR case number 562 of 2024. It is to be noted here that revocated case has been registered on the basis of an FIR lost by Anjan Jyoti Chaudhary of Sapur PS on 15/12/2024. The allegation against the accused is that he has kept one handmade revolver loaded with 5 numbers of live round of live ammunition. Mr. Corem, learned counsel for the petitioner, submits that the accused was arrested on 15/12/2024 and till date he is languishing in jail as of for he is languishing in jail as of for last
2 days.
3 days, and then no search sheet has been submitted till date, and as such the accused is entitled to the culprit, and therefore Mr. Corem has consented to allow the accused to go on bail. Mr. K.K. Das, learned additional PT, has produced the case there before this court, and submits that investigation is yet to be completed. Yet to be completed. Since the mandatory period of detention is already over, and since no search sheet has been submitted till date, the accused is entitled to the culprit. And accordingly, it is provided that on furnishing bond of rupees 50,000 with one security of like amount to the satisfaction of the learned. Trial court, the accused be enlarged on bail.
Item 44, Your Lordship. Same incident, Your Lordship, to a FIR loss, Your Lordship. Same petition, same informant, same PL.
It's same with the other petition.
Same petition. Two FIR loss, your lordship, one register under arms act and other is BNS.
BN number 340.
Timing item number 9.
Oblige, lordship.
My lord, the petitioners, my lord, they have a plot of land, they constructed some portion, my lord. Thereafter, my lord, the rooftop, my lord, floor, for construction of the 3 floors was sold, my lord. The total area is 3,800 square feet, but as per the, my lord, municipal laws, my lord, the staircase, lift and other things are there. It comes to, my lord, less than that. The plaintiff defense respondent, my lord, he has constructed those floors because it was sold in 2010. And he constructed those floors in 2014. He filed a suit. No, I have got 600 square feet less in every floor. So I have to get 1,800 square feet more space. And in that suit, my lord, we filed a WS especially stating that, my lord, that as per the municipal laws, as well as for the staircase and other things, my lord, the 3,000 square, 800 square feet will be slightly less, my lord. But in this matter, they filed a petition, my lord, for appointment of commission, my lord, local inquiry. And that we have objected vehemently, my lord, to let them adduce evidence, my lord. Because our ground is this, my lord, only because the staircase and other things, they consume some space, my lord. And trial court, my lord, doubt, and they are being leading evidence by the other party, my lord, allowed it. So there are several decisions of the, my lord, several high courts, my lord. That first, my lord, they have to probe it. Only for elucidating the matter, my lord, commission can be appointed if any discrepancy remains. Here, nothing is there, my lord. It is very clear, my lord. In the WS also, they have made it clear, my lord. That yes, we have sold 3,800 per floor. But the other things, my lord, makes it less. This is the order, my lord. There are various judgments, my lord. I can place, my lord, 1 or 2, my lord. That first, my lord, they have to produce evidence.
So you have prayed for issuing commission.
No, commission, the other side has prayed. They plenty, my lord. First, they have to probe, my lord. Any discrepancy there for elucidating the matter, only commission can be appointed.
So their prayer was allowed and therefore you are agreed.
Yes, my lord. That why at this stage, my lord, let them adduce evidence.
Let
If-
notice go.
My lord,
Let notice go at this stage. Then we will stay the procedure.
my lord,
We will stay the order.
yes.
Third, Mr. G.N. Sayola, learned senior counsel assisted by Ms. Learned counsel for the petitioner. This petition under Article 7 of the Constitution of India. Read with Section 151 of the Code of Civil Procedure. The petitioner has challenged the order dated 2/9/2024 passed by the learned civil judge number 2 Kasar Chinsor in petition number 525 of 525/P in PS number 119 of 2014. It's to be noted here that by the impugn order dated so the learned trial court has allowed the petition filed by the respondent herein for issuing commission for local investigation. Files the petition and the documents placed on record and also files the impugn order dated so. Issue notice to the respondents returnable in for which step be taken by registered post with within October is the process. And considering the submission of Mr. Tayola learned counsel for the and also considering the facts and circumstances will returnable that the impugn order dated 2/9/2024 is not stated. Is the matter after for weeks.
But
Item 10 for admission.
In this case, on last occasion, I was directed to bring some record regarding to page 37 of this case, my lord. But I need 10 days time, my lord, since it is an old record, my lord, of 2020, 2014, my lord. Regarding dice data of the particular school, my lord.
Lordship, Annexure 6 versus the last occasion, all court please to direct it.
10 days time may be
Whether-
granted, my lord. I have received a communication from the district authority. They are praying for 10 days time to find out the records, my lord.
EO has.
From where the record will come?
From Sunitpur, Dhekiajuli, my lord.
Where the record goes?
It's okay, Lordship.
Third Mr. RC does, learned counsel for the petition. Then Mr. Bora, for respondent number,
For elementary education department, my lord.
elementary education department. Mr. Bora submits that though white order dated 13/2025, he was asked to produce the relevant record in connection with Annexure 6 at page number 37 of the writ petition here. He has not received the record which pertains to the year 2014 and he pressed for granting in 10 days time. Here is accordingly allowed. However, it is made clear that no further sanction will be given to Mr. Bora to produce the record. Please state on which sentence.
Faster than it.
Lordship, the part matter, Lordship, kindly consider the
Okay,
part.
this is I'll keep the matter as part.
Yes, Lord.
Obliged.
Obliged, Lordship.
Come back after 5 minutes.
First, please.
That is, my lord, which your lordship is holding is the previous, is the latest communication. And that is the previous communication which was given by the finance department. If your lordship tallies it, your lordship will, now it's pending before the finance department for final, my lord, disbursement.
Mr. Soliha is available.
I have informed him at 10:30, even.
Probably he's on Lex. Probably he's on Lex in some other court, my lord.
Let him come.
My lord, I'll inform.
After some.
I'll inform.
Gentlemen, 39, 14.
My procedural lordship, my lord. So item number 13, my lord. We have filed this petition, my lord, challenging the impugn order dated 27/6/2024. The plaintiff, my lord, filed a suit, my lord, seeking a declaration that he has some prescribed right over B scheduled land, which is nothing but my lord, a portion of the land which is projected to be the, my lord, approaching path. And he made the present petitioner as a defendant number 1. And subsequently, during the pendency of the suit, defendant number 1 died. Then he made an application for substitution. And admittedly, substitution is barred by limitation. And he made an application, my lord, clubbing together all the prayers. Delay, setting aside of, my lord, abatement, then substitution. But facts remain that, my lord, annexure A, there is no any averments. So what is the date of, my lord, knowledge? And therefore, if it is a, my lord, case of, my lord, knowledge, then he is to make an averment that from this date, from a particular date I came to know, therefore delay has to be counted from that date. Nothing. And court has, my lord, also did not take into consideration that suit was already abated. And therefore, abatement has to be set aside after condoning the delay and then substitution. Facts remain that, my lord, defendant number 4 is the, my lord, builder. And defendant number 4, my lord, contested the suit by filing his WS. Defendant number 1, 2 didn't contest the suit. In the meantime, my lord, we made an application on the understanding that whatever relief was sought for in respect of, my lord, age benefit right, our Schedule B, that has nothing to do, my lord, so far as we are concerned. We have given a, my lord, scratch map in our petition showing that the, my lord, right claim of our B schedule land does not touch our land, my lord. Therefore, we are not going to be affected anyway. Therefore, we are not necessary party. We made an application, my lord, under order on Rule 10, making a prayer for, my lord, non-substitution. That was rejected, and that case is, my lord, in respect to item number 4. Therefore, my lord, question to be decided by the court, my lord, whether court can exercise its judicial discretion without, my lord, looking into the averments made in the petition, where the plaintiff clubbed together all the 3 prayers without having any averments, without setting aside the, my lord, continuing the delay, without setting aside the abatement. And can court straightway, my lord, substitute the legal heirs? And court had the knowledge that one more application is pending, where we have stated, my lord, that we are not necessary party. That was not examined by the court. And hence this petition method. Now, lordship, kindly come to the impugn order. At page, my lord, we have given the typed copy as well as the original copy. No. At page, my lord. At page 88. This is the order passed. May I read, my lord? Plaintiff and defendant number 1, A, B, C, and D are represented. This is absolutely not correct because they did not file any, my lord, Bhokaratnama. Whatever Bhokaratnama was filed, that was on behalf of defendant number 4. Perusal of CR reveals that petition number 2156 of the /22 filed by the petitioner cite for substituting the names of the legal heirs of the deceased defendant number 1 and the names of the legal heirs of the deceased defendant number 1 are so. Perusal of the CR reveals that although the petition is pending for disposal, the defendant side filed a petition number so praying for striking out the name of the defendant. That deals with item number 14. Number 1A, B, C, and D and defendant number 2 being improperly joined. The said petition for setting aside the names of, or striking out the name of so of the defendant and defendant number 2 was disposed of with the observation of the court that any order for striking out their names at this stage might prejudice the plaintiff opposite party, the say opposite party side, and accordingly the said petition was rejected. Perusal of the CR reveals that neither side pointed out to the court that petition number so was pending for disposal. Further perusal of the CR reveals that defendant side has not filed any objection in respect of petition number so, and that it is presumed that the names of so are legal here to the deceased defendant number 1. Hence, their names are to be entered into the cause title of the plaintiff. Accordingly, petition so stands allowed. Where is the, my lord, order regarding continuation of delay, regarding setting aside of abatement? As your lordship knows, it is nothing, my lord, it is not even necessary to, my lord, apprise your lordship that once suit is abated and it is barred by limitation because of limitation, my lord, suit is supposed to be abated. And in that case, the applicant shall be required to file an application for continuation of delay and to explain the cause of delay. And it appears from exhibit from annexure A, simply a petition, my lord, clubbing together all the prayers. Then court is to consider the explanation, and on being satisfied regarding adequacy or sufficiency of the or reasonableness of the averment, it is the discretion of the court to, my lord, condone the delay. And thereafter, court is to proceed further to set aside the abatement, considering the fact that the legal heirs are necessary party and right to the shoe survives. Then only court can, my lord, substitute the legal heirs. And our case is that, my lord, we were no way we are connected with the suit premises. And we are saying we're the best person to say, my lord, whether relief sought for, if granted, would affect our right. And if we say that the relief, even if any granted by the court, will not affect our right, then court has nothing to do. And we are taking, my lord, all responsibility. Even if in future any decree is passed, that decree, even if, my lord, goes against us, we will not raise any question, and we cannot. That aspect of the matter was not taken into consideration, my lord, by the court. And lordship kindly see. So, sketch my foot. 43.
It was 17 petition from A, and except A.
Page 43. वही petition देखो ना ना একটু বোঝানো যায় একটু মারবটা petition আছে না একটু কর ভালো করে না She may kindly turn at page 43. This is the attachment, my lord, which enclosed with each and every registered sale deed. What is the exact position of the suit land and land belongs to us? Have you also got, my lord?
Pardon?
Have you also got at page 43? This is the sketch map, which will, my lord, indicate the exact position of the suit land. 43.
Yes.
Have you also got, my lord? Page 43.
Got it.
My lord, kindly that portion of this sketch map.
That portion of the patch map is the, my lord, plot number 4 belongs to defendant number 3. And my lord, right side, that is my lord, serial number 6. That is 6. That is plot number 4 belongs to no. Itu kan? Plot 6 to. Okay. Then my lord, serial number, my lord, number 5, right hand side of the black portion, below my lord, bottom, is the plot number 5, belongs to plaintiff. And plot number 3 belongs to defendant number 3, plot number 4. That portion is, my lord, defendant number 4. Defendant number 3, sorry, defendant number 3, plot number 4. And he, my lord, claimed a portion of the land measuring about, my lord, 10 into 65 square feet. 10 square feet into 65 square feet is the B-schedule land. And it goes from, my lord, west to east, and took a turn on the northern side. And our land is much above. Hello, kindly see.
So, Mr. Purkes,
My lord.
so according to you, you are not a necessary party. in
Exactly.
this.
Because my lord, suit land doesn't touches our land.
Okay.
But if any relief is, my lord, granted, we are not going to be affected. We
Yes,
are
Mr.
taking all
Bhagwati.
responsibility.
Okay.
Lordship. First of all, the suit is pending since 2019. Let us come to their petitions. At page 60. At page 60. At 60, first para, and the bottom line just before that one, in the said power of attorney.
This is the written statement.
Written statement.
Yes.
Filed by defendant number 4.
Yes.
In the said power of attorney, the owners of the land as mentioned in the above authorize the defendant number 4, who is the managing partner of the partnership firm, namely so and so, so
You
on.
are referring to page number.
Page number 60, first para,
Number.
bottom line of para up 1, 2, 3, 4, 5, 6, 7, 8, 8. That means defendant number 4 contested the suit on behalf of all, including defendant number 1. Defendant number 1 died.
Oh, don't say. Don't say.
You have
My lord, kindly,
Mr. Purkes, so please sit down.
you should play them in the right thing, my lord.
Yes.
Now, since 2019, the suit is pending. Defendant number 4 has been contesting the suit on behalf of all. And there is a power of attorney. Now, first of all, in this, they have added some more documents which is not before the trial court. And they have not given certain documents which is before the trial court. Let us see. It is a common permission, common power of attorney, common building site plan, common, what is that called, memorandum of understanding with all these defendants, contesting defendants. Therefore, the only bill developer has been contesting the matters. Now, at this stage, when we filed the petition, when the defendant number 1 died, we only could know that he died. We did not know. It is the duty of the contesting their defendant's duty to inform the court under order 22 rule 10A. What order 22 rule 10A says? Order 22 rule 10A. Duty of the pleader to communicate the court death of a party. Defendant number 1 advocate supposed to inform the defendant number 4 contesting defendant number was supposed to inform us that yes, so and so has died. So when he was alive, no, he did not object during his lifetime. When he died, his legal heirs started objecting it. They filed a petition. Now the question raises, where they did not inform us. Therefore, we filed a compromise petition or composite petition because we did not have any options. We did not know that when he died. Date of death was not known to us. It was not known to trial court also. Therefore, we filed a petition, common petition at our annexure A of our objections, written objections. In that, at page 105. an application under order 22 rule 4. Second is that an application under rule 22 rule 9. And third is an application under section 5. Why? Because we were not informed about the date. So therefore, we did not have any options to file appropriate petitions. And this petition was considered by the learned trial court and court allowed it. Nowadays is necessary party or unnecessary party, means gender of necessary party or non-gender of parties. Here is this case where documents are common. When documents are common, it is contested by one person on behalf of all. Now at this stage, whether the trial court or any other without evidence, can he is necessary party or unnecessary party, that can come to or not. Here is the case, for side plan is common. Let us come to their revision petition. The permission which they have given at page sketch map, which they sketch map, what is this sketch map? There 44 speaks about it. But there are only black portion, numbers are there. Whether this court, honorable court can find out that these are his position or that position, this position, nothing can be find out from the 43. 43 does not speak anything about it, these documents. Now let us come to the documents which they have been given allowed to construct the permission, construction permission. Construction permission that comes at trace map at page the construction permission which they have given. It is only along with a WS. WS contain, their WS contains 6 number of documents. But now, before this honorable court, this 6 number of documents is missing. When they have filed their WS, that WS has to contain all the documents. That document is not before this honorable court. Therefore, whether this honorable court will be able to decide the matter, whether he is a necessary party or unnecessary party. But even other, I also like to show that, yes, that document which is given there, a common permission document is there, that is there. That is not there. Then let them, first of all, if the honorable court ask them to file their WS, complete WS. Even otherwise, I can show it to this honorable court, that WS. This is the permission, common permission, including the defendant number 1. His name is also there. So whether at this stage, whether he is a necessary party or unnecessary party can be conclusively proved without evidence. Therefore, the right learned trial court.
These 6 documents which were part of the written statement
Has not been filed. Has not been brought before this.
Yes, Mr. Prokes, sir, you produce the document.
My lord, will produce, my lord.
Okay.
Will produce.
So when?
My lord, 2 weeks. My lord.
2 weeks. 2 weeks.
Weeks.
Okay. Heard Mr. Prokes, the learned counsel for the petitioner. And Mr. Bhagavati, learned counsel for the respondent. Mr. Bhagavati submits that the petitioner has enclosed the written statement, but there were 6 documents which were enclosed with the written statement, and the same are not part of this record. And as such, it is provided that Mr. Prokes shall produce those 6 documents before this court on next day by filing an affidavit. List the matter on
4th of April.
4th of April. As part heard.
Lordship, kindly have a notice, my lord. There is no any power of attorney whereby defendant number 4 was authorized to file WS on behalf of all the defendants. Kindly have a note, my lord. There is no attorney.
On next day, we will see you produce the documents
My lord.
first.
43.
Yeah, it was produced for
43.
May praise your lordship. Lordship, this is that matter, if your lordship remembers, that on the basis of the director had stated that SSA Assam had submitted a report wherein my name was not there for the dice details for the year 2011-12. And accordingly, my service could not be provincialized. Now, lordship, the SSA Assam has filed their affidavit. On the last occasion, they had placed the instructions. Now they have filed the affidavit stating that my name was all along there since 2006. Page 48 of their affidavit. They have brought the document on record. Serial number, your lordship will see 2006, serial number 5, Mohar Ali. Page 47.
Mr. Gogoi, you have filed your affidavit?
Yes, yes. We have filed it before on the last week. Probably it is not on record. But it is not on record. We have filed it on Thursday, I suppose. Thursday,
11th.
Filed by respondent number.
Are you sure that you have filed it?
Yes, lordship, we
he
have
has
been given
served.
a copy.
He has been served.
Respondent number 4.
On behalf of respondent number 4.
Okay, in the second half,
Lordship.
we'll call the affidavit for the section.
Obliged.
My lord will have it after some time again. My lord.
My lord, in this matter, finance, there is a communication between the education department and finance are going on, my lord. And the finance is, education is pushing the matter to the finance and finance is again remanding to the, my lord, education department. That's the going on. There is a
Yes,
direct, if
finally,
my lord, if my lord peruse the order dated 13 to 25, my lord, my lordship's order, my lord, that will clarify.
Mr. Bhuya,
My lord,
on 27th of February,
my lord,
they have again sent it to the finance department for concurrence.
my lord, my lord.
Mr. Sobiha, can you obtain the latest status?
Your lordship, as per the instruction, they have just recently sent it, my lordship.
No, not recently, 27 2.
No, my lord. 12/3. 12/3.
No, the
My lord,
instruction is 12/3.
12/3.
As per the instruction, they have sent it on 27, lordship.
Yes.
Lordship, here, lordship, if I may, with a request, lordship, since finance is not a party, let the petitioners implead the finance department because we are a necessary party in this matter. Let them implead, let notice be issued. In the meantime, we'll obtain the necessary instruction, lordship. Because there is a notification to that extent also, lordship, where we are not made a party, at least since our instructions and we are actively involved in the matter, lordship.
Next week.
My learned friend can just implead us. In the meantime, we'll obtain that because we have not received a copy of the written petition also.
Yes.
We are orally, lordship, we are requesting time and again, lordship, but there's a difficulty also for us to qualify. Proceed.
No, can we not dispose of this petition without implementing you as a party? Because only instruction is necessary. What is the status of this file?
Yes, lordship, that, and no, lordship, that can be, or lordship may give us adequate, lordship, if lordship grants us at least 2 weeks time, I may be able to place the updated instruction regarding the file, lordship.
No, you can obtain a verbal instruction because since you are not a party in this
Yes,
proceeding.
Yes, that can be done, lordship.
That is the only assistance we want from you.
Yes, lordship, that can be done.
So after 1 week, Mr. Yeah.
My lord, because the finance concurrence is required, my lord, that I cannot deny, my lord.
Yes.
But only thing is that when there is a specific order, my lord, passed by this honorable court, now, my lord, can they be allowed to communicate in this manner from there to that, from there to that? That is the issue. They can, my lord, it is an order of this honorable court. A mandamus had been issued. They can expedite, my lord. Again, weeks after weeks, I am suffering. I am without a penniless. I am a
Lordship,
teacher, my
one
lord.
thing has to be taken into consideration is that finance is a necessary party. They should have made finance a party in that case.
No, whom I require, my lord, when the matter is
concurrence
there,
is
my
required from
lord,
the panel.
when the original writ petition was filed, my lord, these objections they have never raised. Now, once the order of a mandamus had been issued, now they have come up that we should make this party, that party. I know finance is a necessary party, but even then, my lord, this honorable court, without the party, has asked them to take the instruction, my lord, and the instruction is also clear that the finances return it to the education department, my lord. Now, the education department can do the needful and finish up the matter, my lord.
No, education department again sent it on 27 to
My lord,
2025
my
to
lord.
obtain the concurrence.
My lord.
My lord,
Let-
concurrence
let
has been
Mr.
sought.
Solia obtain instruction.
Yes, my lord can fix it after a week, my lord.
After
My lord.
heard,
By Eviction
heard
police.
Mr. Here, we are learned Court of Sir A. Bukon, learned standing counsel for the respondent number 1, 2, 5, and 6. 5 and 6. Mr. Bukon, learned counsel for the respondent number 1, 5, and 6 obtain necessary instruction. And place the same before this
25
court
to
and submits that. As the financial, no, as the concurrence of the finance department is necessary, the matter was, no, the file bearing number 228806 was again sent to the finance department on 27/2/2025, seeking their concurrence for payment of salary as per direction of this court. At this assess, Mr. Solia, who is on a learned standing counsel who is present in this court, is requested to obtain necessary instruction as to the status of the file numbers and so, and to apprise this court on
2nd of April. 2nd April.
2nd of April.
My lord, can it be on 26th, my lord, because Eid is coming, my lord, if we get something before Eid, my lord.
That may be granted because we are processing the file,
Second of April. Well, a copy of the written communication produced by Mr. Bukon before this court shall be furnished to Mr. Solia during the course of that. Deeply.
Oblige, my lord.
Item number 16.
My lord, there is an interim direction that may.
Interim order passed, shall concur.
Oblige. My lord, my learned friend Soliha's name may be come in the cause list, my lord, as a finance.
Okay, this shall reflect the name of Mr. Soliha, learned standing counsel for the finance department in the context.
Oblige, my lord, highly oblige.
May it please your lordship, my lord.
Yes.
Second appeal, my lord. The issue is whether the suit was barred by time and which article of the Limitation Act will apply, my lord. Because here what had happened, my lord, admittedly a loan was taken. The trial court, while passing the judgment, held that it is a loan and hence covered by Article 21 of the Limitation Act, where the limitation will start from the date of giving the loan. But went ahead to hold that the date of demand will extend the period of limitation. Now, the first appellate court, in fact, the first appeal was filed before this honorable court, my lord, before the jurisdiction was changed. Right? The appeal was admitted, but later on it was sent back, my lord. Now, the learned first appellate court has held that no, it was a deposit, and therefore the limitation will start from the date of demand, my lord. Lordship knows that when a loan is given, the period of limitation to file the suit starts from the date of the loan. But if it is a deposit, then the limitation starts from the date of demand. Simply, my lord, if I go to the bank asking for a loan, the bank may give me a loan and the bank will, the limitation will start from the date of the loan. But if I make a fixed deposit in a bank, my lord, the limitation for taking the money from the bank will not start from the deposit, my lord. It will start from the date I make a demand to the bank that please give me back my deposit. So now, if your lordship, I take your lordships to the plaint. Lordship will kindly turn to page 8 of the memo of appealment.
Yes.
Paragraph 4. That the defendant number 2 knows the plaintiff and his family members very well. Out of this friendly relation, the said defendant approached the plaintiff for loan and persuaded the plaintiff to lend a sum of rupees so and so and so and so, and a sum of rupees so and so and so and so. It is pertinent to mention here that the defendants borrowed the said money in the name of the defendant number 1 and assured the plaintiff that the said sum of loan amount shall be returned immediately to on his demand. Now, if your lordship takes up the Limitation Act,
yes. Article
19, 20, and 21 and 22 will be relevant.
Yes.
Article 19 is for simple loan, my lord, for money payable for money lent. It is when the loan is made, 3 years from the loan is made. 21, my lord. For money lent under an agreement that it shall be payable on demand. It is 3 years from the loan is made, not from where it is demand is made. But if your lordship comes to 22, it is for money deposited under an agreement that it shall be payable on demand, including money of a customer in the hands of his banker so payable. It is 3 years from the demand is made. Therefore, admittedly from the pleadings of the plaintiff, it is a loan. So if it is loan, my lord, it will come under Article 21. And here the money was given on 2003 and the suit was filed in 2007, my lord. January 2007. It is beyond the period of 3 years. In fact, my lord, in a similar case, there also the trial court held, we had to come on a second appeal, my lord, exactly on similar facts, my lord. This honorable court was pleased to admit the second appeal. The substantial question of law which I am urging will be similar, my lord, for your lordship's kind consideration. There also the facts were similar, my lord.
So the first appellate court has held that Article
22 will
be applicable.
22 will.
And according to you, it is Article
21. Either 21 or 19, my lord. 19 is simply a loan. 21 says that it is a loan which is payable on demand. Even then, the limitation starts from the date of loan, my lord. And that is nicely, I can place the judgment of the Supreme Court also. But the Supreme Court has, my lord, distinguished what is a loan and a deposit. May I just hand over this book, my lord? 2019, 13 SCC, page 747, paragraph 14. Of course, my lord, that was while interpreting some provisions of the Income Tax Act, my lord. If your lordship directly goes to page 770, paragraph 14. Lordship has got it, my lord. In any case, we would like to point out that there is a settled distinction between the loan and deposit. It is rightly held by the tribunal on the analysis of various judgments of our courts, which are referred to by Mr. So-and-so as well as already noticed above. There are three main tests between the loan and deposit. These are: number one, a loan is payable immediately on receipt thereof as per the directions of the lender, while a deposit has a term for repayment, which may be fixed date or it may be as per the terms and conditions of the agreement. The loan is obtained at the request of the borrower, while a deposit is made at the instance of the depositor. The limitation period in case of a loan starts from the date of the loan, while it starts from the date of repayment in the case of deposit. So here the loan has to be at the instance of the borrower. Para 4 says that I had asked him for the loan. So it is at my instance. Deposit will be at the instance of the depositor. And I am a private limited company, my lord. How will I keep a deposit, my lord? I am not a bank.
Third, Mr. N. Becker, learned counsel for the appellant. This appeal under section 100, with order party 2 of the Code of Civil Procedure is directed against the judgment and decree dated 5/12/2024 passed by the learned additional district judge number 3. Kamrup M. at Guwahati in money appeal number 20 of 2022. It's to be noted here that by the judgment and order dated, judgment and decree dated so and so, the learned First Appellate Court has dismissed the appeal filed by the appellant stroke defendant and thereby upheld the judgment dated 25/2/2015 passed by the learned civil judge number 2, Kamrup M. Guwahati in money suit number 5 of 2007, whereby suit of the respondent stroke plaintiff was decreed. Where is the memo of appeal? And the grounds mentioned therein as well as the suggested substantial provision of law. Then also part of the impugned judgment and decree dated 5/12/2024 passed by the First Appellate Court. This appeal is admitted on the following substantial question of law. 1. In view of the categorical statement made in the plaint by the plaintiff, especially in paragraph number 4, that the amount of rupees 6 lakhs only was given to the appellant herein as a loan, the finding of the learned First Appellate Court that it was an amount deposited by the plaintiff with the appellant and that Article 22 of the Limitation Act to apply is justified in the given facts and circumstances on the record. Let notice be issued to the respondents, returnable and forward. Step be taken by registered post with AD and also by usual process within a week from today. Call for the record from the learned First Appellate Court. Place the matter after forward. The court may also consider framing of any other substantial question of law if found necessary at the time of hearing after issuing notice to both the parties. Place the matter after forward.
There is an I, my lord.
But there are any execution cases filed
Not
immediately?
filed, my lord. May I place one thing, my lord? When the first appeal was filed before this honorable court, my lord, there was an interim order staying the original decree, and a bank guarantee was given by us before this honorable court, my lord. So therefore, if your lordship says the execution of the judgment and decree, my lord, we will extend this bank guarantee. I'm placing the certified copy, my lord. Lordship will see the name of the parties, it is same, my lord.
Heard Mr. and take a learned counsel for the petition. Learned counsel for the application. This interlocutory application under order 41 rule 5 of the Code of Civil Procedure is preferred by the applicant who is staying execution of the judgment and decree dated 25/2015 was by the learned
My lord, it
civil
will
judge
also be
number 2 Kamrup Ahmed.
5/12/2024, my lord.
Pardon?
5/12/2024. It is
You
the
should
appellate.
mention it as
Sorry, my lord. It's the appellate judgment. It will be both. It will be both, my lord. I'm sorry. Seen it.
you have to make necessary corrections. Let it be on next step. Yeah. As read for by Mr. Enteka, learned counsel for the applicant,
Lord, you will list it next week, my lord.
list the matter the next week. So as to enable Mr. Decker to make necessary correction in that aspect of the
My lord.
case interlocutory application. You can take back this.
I'll take
order.
back. Okay.
Item number 17 for orders.
Yes.
Lordship, I am for the respondent number 1.
What happened to the appellant?
Lordship, last 2 occasions also they have not appeared.
This RSI is yet to be admitted.
Yes, Lordship, there is an IF for delay
This is for
condemnation.
condonation of delay.
Yes, Lordship, 201 days of delay.
It has earlier never been listed. None appears for the applicant on call. However, Miss, your good name,
F. Ahmed,
learned counsel for the respondent present.
number 1.
Respondent number
1.
Respondent number 1 present. Seen the order of the laws in my court dated 9/1/2025. List the matter after a week. In the event of subsequent non-appearance, appropriate orders will follow.
Deeply.
May I please your lordship?
Hmm.
My lord, kindly see the office note, last office note, my lord. That is sometime in January 2025, my lord. Very soon. First item receipts, absolutely.
So in respect of respondent number one, he could not be found out.
In so far as respondent number 2 is concerned, his wife has received, so it may be deemed as complete, my lord. And respondent number 1, my lord, will take fresh steps by giving correct address.
Madam, you are for?
That's me, lord.
Three.
3 is already complete, my lord, they have appeared. This IA is pending since 2018, condonation for condonation of delay, only 55 days, my lord. Right.
Third is Chaudhary,
Yes, it
learned
was-
counsel for the applicant. And Ms. M. Chaudhary for respondent number 3. Office note dated 8/1/2025 indicates that notice upon respondent number not be served as he was not found at the address mentioned in the notice, and the local residents had also no knowledge about him. And in respect of respondent number 2, it is stated that respondent number 2 is not at home, and state of him notice was received and signed by his wife. And as such, notice deemed to have been served upon respondent number 2. So press step be taken upon respondent number 1 by registered post with AD and also by the process within a week from today. This is the matter after 4 weeks. Most of like 2018 matter.
Matter number 20.
In this matter, Lordship wrongly listed for order column, Lordship.
Yes, Lord, it ought to have listed for the admission, Lord, because the
Order-
cross objection has not been admitted yet. That has
Kindly see,
been filed by the
Lordship, order
respondent.
dated 27/11/2024, Lordship.
Third is the
PW, Lordship.
learned counsel for the appellant.
Cross object, Lord.
Cross objector respondents, we are for the appellant.
You are for the appellant.
Yes,
Cross objector struck respondent.
yes.
And madam for the appellant. It is submitted at the bar that the matter is wrongly listed in the order column, and it would to have been listed in the admission column under order 41 rule 11 cities. Accordingly, it is provided that residents are list the matter in the admission column of next day. List the matter of 1 week.
Lordship, a date may be fixed, Lordship.
When?
26.
26. Diplo.
That's
As per the office note, it is unclear as to whether respondent number 3 has been served or not. No unserved notice has been received, neither AD card. She resides in Switzerland, Lordship. If Lordship may direct, I will take fresh steps.
Third, Mr. A. Kapote, learned counsel for the applicant, and madam
Yes, Dasgupta for respondent number 1 and 4.
for respondent number 1 and 4. Office note dated 11/3/2025 indicates that neither AD card nor unserved notice in respect of respondent number 3 has been received. The learned counsel for the applicant submits that he will take first step upon respondent number 3. Accordingly, it is provided that the plea taken by registered court with ADA multiply the process up to date. This is the matter after query.
Obliged.
May I please, your lordship? I am
You are for
appearing,
respondent.
I am for respondent claimants, 1 to 4. My learned friend was sitting here, but
Who is
L. Sharma. Let it be taken at 2. Obliged.
Item 23, he has no objection.
I
In
have no
substitution.
objection. Well, I for substitutional legal heirs, someone has expired. He left 1 2 days.
The appellant number 1 had expired, my lord. So one is application for conversion delay.
Heard Mr. Sharma, learned counsel for the applicant, and Mr. Gogoi for respondent.
1 to 5.
Respondent number 1 to 5. This interlocutory application under section 5 of the limitation act is referred for continuation of delay of 212 days in filing substitution of the legal heirs of the appellate number 1, namely Abdul Majid. Mr. Gogoi, learned counsel for the respondent number, so submits that he has no objection in the event of allowing this application. Then what is the ground?
My lord, actually, my lord, this appellant number 1 expired. Legal heirs, actually, they did not have any knowledge about the case. The case is pending. They do not know about it. So after death of the father, there are other appellants also who are conducting the case.
No, in which paragraph of your petition
My lord.
you have mentioned it? Explain it.
My lord.
Paragraph 4.
My lord. Paragraph number 4, my lord. Paragraph 4 and 5, my lord. 4 and 5.
Whereas Mr. Sharma, learned counsel for the applicant, submits that the grounds for failing to file the application within failing to file the appeal within the stipulated period is explained in paragraph number 4 and 5 of the application. I have carefully gone through the statement and environment made in the paragraph number 4 and 5. And it appears that the delay of 212 days is sufficiently explained in the aforementioned paragraph. Then accordingly, this court is inclined to condone the delay of 212 days in filing the substitution of the legal heirs of the appellant number 1. In terms of above this, I stands close. You have to file corrected this posted in the appeal.
Well, we can. Otherwise, the registry may correct it. That can be done. my lord, Because
Preparations to the
Registry shall make necessary correction in the posted of RSA number 38 of 2012.
Well,
List after 4 weeks.
The main case is ready for hearing. 212 meters. RSA.
When do you want then?
Approximately fixed for hearing. RSA.
Okay, this is a list of matter after 4 weeks. In the hearing column.
my lord.
Obliged.
In the main petition, you take down hard Mr. Chaudhary for the petitioner. Then Mr. A.M. Bormuya for the respondent number.
Respondent had a long list, my lord, for private respondent.
You filed a list to him.
My
Not the name
My-
of the.
my detail.
Yeah. Then Mr. Sahewala for respondent number 10 to 13. Mr. Sahewala submits that he may be granted 2 weeks time to file his affidavit in opposition. Here is accordingly allowed. This is let the matter after 2 weeks, along with the I number 322 of 2024. On that day, an endeavor will be made to finally hear and dispose of the petition.
Keep low.
May it please your lordship. Your lordship, this is an application for refund of the statutory deposit of rupees 25,000, your lordship.
The case has been disposed of.
Yes, your lordship, I ordered it 1/8/2024, your lordship.
Part miss,
P. Bodhapur.
learned counsel for the applicant. This interlocutory application is preferred by the applicant, National Insurance Company Limited, for refunding the statutory deposit of rupees 25,000 made in the MSC appeal number 170 of 2011. This Board of Learned Counsel for the applicant submits that MSC appeal number 170 of 2011 has already been disposed of. On who is that?
1/8/2024, your lordship.
On
1/8/2024. Page number 4, your lordship, para number 4.
on 1/8/2024. 1/8/2024. And in the said judgment and order, no order has been passed for refunding the statutory deposit. And accordingly, she contented to pass necessary order for refunding the amount, refunding the statutory deposit of rupees 25,000 made in the MSC appeal number 170 of 2011. Here is accordingly allowed. Recess shall refund the statutory deposit of 25,000 in favor of the applicant, which has been deposited in MSC appeal number 170 of 2011. In terms of above this, I is such closed.
Oblige, your lordship.
Lordship, this is a delay condonation petition, Lordship. By office not dated, Lordship, 6/3/25, service is complete, Lordship. Delay of 33 days.
Lordship, I may be for respondent number 1 and 2. Claimant, we have no objection so far as delay is concerned.
You have no objection. Okay. Third, Mr. Is a Soikia learned counsel for the applicant and Mr.
M. Talukar.
N.
M. Talukar.
M. Talukar, learned counsel for the respondent number
1 and
1 and 2. And in respect of respondent number 3,
Service is complete, Lordship. As per office not dated 6/3/25.
Office note dated 6/3/2025 indicates that service in respect of respondent number 3 has already been completed. But the respondent number 3 remain unrepresented today. Mr. Soikia, learned counsel for the applicant, submits that this interlocutory application is preferred for condonation of delay of 33 days in preparing appeal against the judgment and award dated 28/6/2024, passed in MSC case number 23 of 2019 by the learned member Motor Accident Claim Tribunal Moria. So Suikia further submits that the appeal could not be preferred in time on account of what is the reason?
Also, there is delay in getting the certified copy of judgment and some official delay was
In-
also there. Paragraph 4 lordship of our petition.
Follow. Within the stipulated period of time. As the certified copy of the impugned judgment and order could not, certified copy of the judgment and order dated 28/6/2024 could not be obtained in time. And the same has duly been explained in paragraph number
4.
Paragraph number 4. And as such, it is contended to condone the delay of 33 days. Mr. Talukdar, learned counsel for the respondent number 1 and 2, submits that he has no objection in the event of condoning the delay. But having heard the submission of learned counsel for both the parties, I have kept onto the petition, the documents placed on record, and also the statement from government made in the paragraph number 4. It appears that the certified copy of the judgment and order dated 28/6/2021 could not be obtained in time. And the delay is not intentional, or rather it is circumstantial, and the same has been duly been explained in paragraph number 4. And as such, this court is inclined to condone the delay of 33 days in preparing the accompanying appeal. In view of the order passed in I number 3499 of 2024, now the registrar shall register the appeal and list the same before the court as soon as practicable.
Lordship, my name may be reflected in the appeal when it will be listed for admission.
Appeal is yet to be registered.
Lordship, otherwise,
Pass the order
my name-
when the appeal
when it will be listed,
is
my
registered
name-
and placed before the court.
my name may not be reflected in the list.
Pardon?
When it will be listed for admission, my name may not be reflected in the list.
Okay, the name of respondent number 1 and 2
Mr. M. Talukdar.
shall be reflected in the case.
Number 28.
Wait, this is the lordship. Lordship, we need an adjournment in this case because we have filed the objection today, lordship. The official signatory was not there.
Not
We
placed
had-
on record.
Lordship,
Not on record.
Not on record. We had asked him, he said he when the matter reaches, otherwise I would have mentioned in the morning. He said
Your
he when the
lordship,
matter reaches.
I have objection to mentioning the matter because your lordship go through the order passed in the IA. 12/2/25, insurance company took time to get instruction. What instruction, I don't know. Again, the matter is listed on 19/2/25, when they took time to file objection, 19/2. Today it is 17/3, and today they are filing.
At times it happens,
Otherwise, I
lordship,
never
if not-
objected in taking adjournment.
Lordship, it can come tomorrow. I do not have any, it can, with our.
Not tomorrow is
Not
hearing
tomorrow is
day.
not possible
Day
because
after-
scanning,
Day after, no issue. Yeah.
Your lordship, according to now new system of filing, the scanning process is there, so it will take 2 to 3 days.
No, I no like
No, no, no.
In the new,
Only in additional affidavit and wakalatnama. Other than additional affidavit and wakalatnama, scanning is
Then on Friday,
Friday.
heard Mr. D. Mondal, learned counsel for the applicant, and Ms. R.D. Mazumdar, learned counsel for the respondent. Ms. Mazumdar submits that she has filed objection today in the section, and the same is not placed on record. Accordingly, it is provided that places the this matter on Friday.
21-3.
And in the meantime, the affidavit, in the meantime, the objection filed by Ms. Mazumdar shall be placed on record.
highly obliged.
Oblige, your lordship.
Item number 29 through VC mode.
Yeah, please, sir. This is a IA for the stay of the operation of the impugn order dated 3/2/2024 passed by the learned district, additional district judge, Sonitpur Tezpur, where your lordship, it was page number 9 is the impugn order. He was asked to pay 15,000 as a monthly maintenance and also 30,000 as a cost of the proceedings, where he has already paid 30,000 for the cost of proceedings, where 15,000 is beyond his reach because he is earning only 30,000 per month, your lordship, where 50% of the total income has been asked to give to the wife, whereas both sides have submitted their assets and liabilities before the court. The assets and liabilities clearly states he has submitted the bank statement as well as the tax return. Everything shows that his income is 30 to 33,000. So he doesn't deny that he will not give any money. He's just saying that 15,000 is beyond his reach and capacity. So he is asking on the last occasion also, your lordship, it was heard by the court and a order was submitted before the court that it has been fixed tomorrow in the lower court, where pressure has been given upon the petitioner to submit the entire money, and it has been fixed. The next date is fixed for the payment, and the order from the Honorable High Court. This order has also been given before this court in the last occasion also, where the other side has filed a petition under 28A of the Hindu Marriage Act and prayed for taking action against the petitioner. Ready? On the last occasion, none appeared before the court. That is the reason why no order could be passed, and it was fixed today, as the matter is fixed tomorrow, Your Lordship.
So
the lower
this interlocutory application is for staying of the operation of the
of the
order.
order
Dated
dated
2nd of
3/2024.
3rd of February 2024.
Yes.
Manoj, if I may say something, Manoj, this CRP, in the main CRP, they have not even taken any steps till today. I have only received the copy of the IA, and that is why, my lord, my wakalatnama is on record only for the IA. If your lordship takes up the CRP for a minute, lordship will find that ever since the CRP has been filed, they have not taken any steps for service. And that is why I do not have as on date a copy of the CRP. That is how things stand at the moment. My lord, how can the stay application be taken up without serving a copy of the CRP, my lord, when the notice has been issued and they have not taken any steps in the matter? This is the conduct of the husband, my lords.
For that, we need to take instruction because, Your Lordship, we are the newly engaged counsel in this case. Earlier, there was different engaged counsel.
Yes, my lord, that is what has happened. There has been a change of counsel and the earlier counsel.
Can you furnish a copy to him?
Yes, we will furnish a copy. Now the order is about the IA, Your Lordship, for the stay of the operation of the
How
order,
can it
Your
be stayed, my
Lordship,
lord? It has to be heard on its
the matter
merits.
has been fixed tomorrow for an order from the Honorable High Court, and they have also filed a petition under section 28A for taking action against the petitioner also.
Lord, he
So,
is admittedly a
15,000,
defaulter,
Your
and
Lordship,
this he has
is beyond
admitted
his
in the IA.
capacity. He is not denying the fact he will not give.
What is the source of income?
He's a cloth. He is a small stall. He is giving around 350 as a rent, and he's selling cloth as a wholesaler. On the other hand, Your Lordship, the other side is a tutor. He is a tutor. He is earning through private tuitions also.
No, the CRP has to be heard.
We-
my lord. This is the finding on merits.
In the CRB also, we have submitted the details, the assets and liabilities also. They're in the page 46, where in details we have given. It contains even the income tax return. Also the dependent father and mother who are suffering from different ailments,
Are you income tax assessee?
and also
Are you income tax assessee?
no, but no. Still, we have submitted the income tax return. We are maintaining the income tax certificate.
Whether you have received any notice from the income tax department for filing your return?
No, Lordship.
Then
They are maintaining the income tax certificate because he's earning in around 3,50,000 to something. So he's maintaining his income tax certificate. And on the page number 46, Your Lordship, is the Huzai Municipal Board has given the authority of 350 rupees. Is the detail of the stall where he is giving 350 rupees as a monthly rent to the Huzai Municipality Board. The last order of the lower court also reflects that he is submitting 10,000 rupees.
heard Mr.
Yes, Ahmed.
S. Ahmed, learned counsel for the applicant, and Mr. Ganguly for the respondent. Mr. Ganguly submits that though he has filed Wakalatnama in this interlocutory application, he has not filed his Wakalatnama in the CRP. Is
Lordship,
there any
Lordship.
necessity of filing Wakalatnama in the CRP?
Perhaps not, but at least, my lord, they will give a copy because they have not taken any steps. Lordship will find from the record there are no steps
Then
taken by the
that, in
previous
the
one.
CRP, no notice has been issued. And the copy of the petition in CRP has not been furnished to him.
Yes.
And as such, he prayed for granting him some time. You want to file objection?
Yes, my lord, I'll have to file an objection, my lord, because of the various conflicting stands that they keep
Then
taking from
prayed for
time to
granting
time.
him some time to file objection. Here is accordingly allowed. This is a list the matter on when to be listed.
No, if it is possible after Bihu, my lord, immediately after the.
No.
Or Lordship will then have it on
First week
3rd
of April.
3rd of April, my lords. I'll come.
In
3rd
the
of April.
meantime, Mr. Ahmed, learned counsel for the applicant shall furnish a copy of the petition in CRP to Mr. Ganguly within a period of 1 week from today.
Yes, my lord.
List it on
3rd of April.
3rd of April.
3rd of April. Well, let the CRP come up for admission, my lords, perhaps. That will be better, my lords, instead of arguing the stay itself.
CRP notice has not been issued.
Notice was issued by the court, my lord, but they have not taken any steps. That is why no copy has been received by me, my lords.
No order was passed. Yes. Heard Mr. Ahmed, learned counsel for the petitioner. Then also heard Mr. Ganguly, learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, the petitioner, namely Sujay Mitra, has challenged the correctness or otherwise of the order dated T2/2024 passed by the learned additional district judge Appellate Summit Court. As for in BJ case number 48 of 2022 arising out of title suit divorce number 59 of 2022. Peruse the petition and the documents placed on record and also peruse the impugn order dated 3/2/2024. Let notice be issued to the respondents returnable in. Third of. Returnable on 3rd of April. But no formal notice is required to be issued since the respondent is represented by Mr. Ganguly, learned counsel. Place the matter on 3rd of April.
I am waiting for the respondent, my lord. The wife of the deceased.
Your lord,
I am waiting for 1, 2, 3, my lord, and my third appellate is waiting for 4 and 5.
1 to 3.
I filed an IML for enhancement. So I'll have to argue on that. They want to file objection, they want some time to
kindly
file
3
objection.
weeks. We will have to file the objection, kindly 3 weeks time may be granted.
Malik, can you fix on 7th and 8th of April, my lord?
When?
8th of April. That will be beyond 3 weeks. They will get sufficient time.
But this is already fixed for hearing
Yes.
sometime. My senior friend has filed on IA by saying that since by not granting the physical prospect, that is 50%.
Yes.
It can be taken up while hearing the matter. So there is need.
Yes, it will be heard along with the appeal.
Yes, yes. On 8 April, my lord, that will be better. The long one, since 2014 is better.
Heard Mr. R.P. Sharma, learned senior counsel,
No,
assisted by.
They are the appellant.
No, this interlocutory application.
Yes.
You are assisted by no one.
Assisted by. His name is. नाम तो कोई दिया.
Learned counsel for the applicant. And madam,
You right,
for the
NIC.
respondent,
For the NIC. Yes, your
opposite
lordship.
party.
And National Insurance Company, your lordship. For the IA,
Yes, national insurance company. This interlocutory application is prepared by the applicants, by 5 applicants for enhancement of the monthly
Of the my lord, compensation, amount of compensation.
for enhancement of the compensation on account of promotional prospect and enhancement of the monthly salary and allowances of the petitioners. This is no, on account of the allowance of the petitioners. This is husband, namely let Dr. Ravi Kipa. The learned counsel for the respondent, National Insurance Company Limited, submits that she may be granted 2 weeks time.
3 weeks. 3
3
weeks.
weeks time to file
Objection.
in this application. Where it is allowed, dismissal is the matter of 10th of April.
Malik, can it be 8, my lord?
8.
8 of April. And entire matter may be hard, my lord, on the day. Along with the IA main matter also.
In main appeal, you take down. Part Roy, learned counsel for the appellant. And Mr. R.P. Sharma, learned senior counsel for the respondent number
1 to 3.
1 to 3. And
And
Mr.
my
Gupta
junior
for
appears for
4 and 5.
4 and 5.
Yes.
4 and 5. As agreed by learned advocates of both the parties, recess shall list the matter on 8th of April along with IA number 3917 on that day, an endeavor will be made to finally hear and dispose of both this appeal and the IA.
Not obliged.
31.
Petition matter may kindly pass over for the time being. My senior is in legs. Obliged.
32.
Nothing. My lord, there is a review petition, my lord, in respect to the, my lord, judgment passed by your lordship, my lord. We have some ground, my lord. There is an earlier title appeal, my lord. That title appeal, my lord, there is a specific direction regarding handwriting expert. And on the basis of that direction, learned chief, he passed the judgment, my lord, by complying that judgment, my lord. But this fact was not brought before this court, my lord. So in deciding that second appeal, your lordship could not peruse that judgment, my lord. We have that judgment is in the record, my lord. But both of party, neither party hesitated that point before the honorable court or not noticed before the honorable court.
But that direction was issued by which court?
Title appeal, my lord, civil judge, to remand the matter. Earlier, this title suit was dismissed, my lord. Against that, the plaintiff preferred the first appeal, my lord. That suit was remanded. That appeal is remanded back to the trial court for specific direction for obtaining the handwriting expert, my lord. But although they have filed a petition for handwriting expert, my lord, gave opinion that it is not materials are not sufficient for comparison. So second attempt may be conducted on the basis of the supplying some more materials. But plaintiff did not further done nothing for sending the signature. Although that signature is available in the record still, my lord, because the defendant filed his written statement, evidence also there, that materials may be sent to the handwriting expert for second opinion. So that particular point was not, my lord, brought before your lordship. So I am drawing your attention, my lord, this page 80, my lord, earlier title appeal, my lord. Present appeal memo in appeal memo page 80, my lord. Present appeal memo, review petition. Present appeal memo is page 80, my lord.
18.
80. My lord, last but one, my lord. Operative part. In the result, finding merit in the appeal, it is allowed on contest, and the judgment and decree passed by the learned trial court entitled suit number so and so, dated Iman is set aside and quash, and suit is remanded back to learned trial court with a direction to send the exhibit 1, the agreement for sale to expert, with the burden to bear the cost by the plaintiff appellant, and to decide the suit afresh on the basis of opinion of expert on exhibit 1. And the case and in case the parties will feel that the evidence will be examined, there should be proper opportunity to the parties to it. So this is the direction, my lord. Only this direction, my lord, the judgment was passed, my lord. 74. That is it. My lord, in this suit, my lord, page 144, on the basis of the remand order, para 11, my lord, last part. Again, the learned appellate court remand the case record with direction that the exhibit 1 may be sent to the expert for opinion, and on the opinion of the expert, case may be determined. The learned appellate court also directed to scrutinize the evidence of the parties if they wish to adduce any fresh evidence. However, in view of the direction given by the learned appellate court, the disputed signature of the defendant Desmond Anthony was obtained in the process and also sent to the expert for opinion. Accordingly, the expert
You are
sent the
reading page number?
page number 144,
144, yes. Paragraph number?
paragraph number 11, Miller.
11, yes.
I'm again reading, Miller. The learned appellate court remand the case record with direction that the exhibit 1 may be sent to the expert for opinion, and on the opinion of the expert, the case may be determined. The learned appellate court also directed to scrutinize the evidence of the parties if they wishes to adduce any fresh evidence. However, in view of the direction given by the learned appellate court, the disputed signature of the Desmond Anthony was obtained in due process and also sent to the expert for opinion. Accordingly, the expert sent the opinion stating herein inter alia that the document in connection with the case had been carefully and thoroughly examined and compared with the supplied standard signature in all aspects of the handwriting identification and direct detection of forgery with necessary scientific aids available in the Directorate of Forensic Assam, Railibara, Guwahati, 19. The expert further opinion that he examined and compiled the question signature with the specimen signature in a number of sitting, but could not possible to express a definite opinion regarding the authorship of the question signature on the basis of the comparison with the materials in hand. However, the expert also gave a remark that another attempt may be taken to attain at the definite result if some signature of English of Desmond Anthony preferably taken around 1994 be sent to the expert to opinion. If the careful scrutinize the opinion of the expert, then it is evident that he could not ascertain in his normal course of examination that the specimen signature of the concerned person is resemble with the question signature. Do the expert get reserve the second test, but he could not examine the result?
Okay, there was a direction of the first appellate court.
As per direction, my lord, the trial court passed this order, my lord. Trial court, my lord. That and dismissed the suit, my lord. Again, he dismissed. Earlier, suit was dismissed after the remand because the absence of expert opinion, my lord, the fault of the plaintiff, my lord, that again dismissed.
No, whether the expert opinion was obtained.
No, my lord. Second time they have not
Taken any.
Not taken, my lord. They have not taken. So the direction is that on the basis of the expert opinion, you pass the judgment. So it is not available.
No, if the person concerned has not taken any step, then
no, he has not taken step, my lord. Meantime, the person concerned, my lord, he died, my lord, after giving evidence, my lord. But his some signature are there available in the written statement is there. The my lord, the other document, summons about everything is there. So they should have taken, my lord.
okay, let notice go at this.
Yes, my lord. That will be better, my lord.
Let the other side appear.
Yes, my lord.
Heard Mr. P.S. Decker, learned senior counsel assisted by Ms. Learned counsel for the appellant. This application under order 47, rule 1, read with section 114 of the Code of Civil Procedure is preferred by the applicant. For review of the judgment and order dated 9/12/2024 passed by this court in RSN number 219 of 2015. Peruse the application and the documents enclosed therewith, and also peruse the judgment and order dated 9/12/2024 passed by this court in RSN number 219 of 2015. Let notice be issued to the respondents, returnable in 4 weeks. That be taken by registered post with AD and also by user process within a week from today. Place the matter after 4 weeks.
33,
May it please your lordship. This is a review application against an order dated 22/11/2024, asked in CRP IO number 483 of 24. The only thing is that I have filed the petitioner have furnished me the copy of the legible copy on 2/5/2024. However, this honorable court has reflected it was filed on 2/4/2024 and rejected my prayer for allowing me to file WS. What has happened is that there are two impugned orders. First, against the petition whereby my adjournment to file written statement was rejected. And second was my petition for cross-examination of the PWs was also rejected. As regard the second prayer, this honorable court has allowed. As per my first prayer for allowing me to file WS, it was rejected, holding that I have received the copy on 2/4/2024. However, in my CRP IO, I have clearly stated that I have received the copy on 2/5. And as per Rule 10 of the Assam Land Grabbing Prohibition Act, 14 days was granted. And the date fixed was on 4/5/2024. So only 2 days has passed. If your lordship may come to page number 18 of my review petition. Paragraph 7. It appears that the petitioner herein received the notice on 22/3/2024 and admittedly no legible copy of the documents were enclosed with the said notice, for which they had filed a petition before the learned tribunal for providing a legible copy of the documents, and the same was furnished to them on 2/4/2024. But however, in my petition, I've stated it was 2/5/2024. As per Rule 10 of the rules of 2013, written statement has to be furnished within a period of 14 days. But even after elapse of 14 days since furnishing of the legible copy on 2/4/2024, the petitioners could not file the written statement. As such, this prayer was rejected, your lordship, to file my written statement.
You have filed the written statement on?
I have received the legible copy on 2/5/2024. 2/5, your lordship. And the next date was on 4/5. On that day, I have filed a petition seeking adjournment to file WS. However, it was rejected.
Okay, let notice go.
Yes.
Heard, Mr.
J. Das.
Learned counsel for the petitioner. This petition under section 114 due to order 46 rule 1 of the Code of Civil Procedure. The petitioner has tried for review of the order dated 22nd of 11, 2024 passed by this court in CRP IU number 483 of 20. Where is the application? And the documents plus of record and also produce the order dated 22nd of November 2024. That notice be issued to the respondent, returnable in 4 weeks, that be taken by the registered post with AD and also by the process. List after 4 weeks.
Deeply obliged.
34,
May I please? This is a condonation petition, my lord. Today is the first day, my lord. At this stage, notice may go, my lord. Here, a delay of 93 days for filing of appended CRP, my lord.
Heard, Mr. Soikia, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for confirmation of delay of 93 days in preferring connected civil revision petition against the judgment and order dated 30/1/2024 passed by the learned special tribunal Gwalpara in LG case number 30 of 2014. Let notice be issued to the respondents,
My lord,
opposite party,
all opposite party, my lord.
by registered post with AD and also by usual process within a week from today. Please the matter after 4 weeks.
Obliged.
36.
My lord, limitation is barred by only 49 days, my lord. It is for the first time, my lord. Notice may be issued, my lord.
Hardness,
L. Sharma.
learned counsel for the applicant. They entered the application under section 5 of the limitation act is prepared by the applicant that New India Assurance Company Limited. For condonation of delay of 53 days in filing connected appeal, MSc appeal against the judgment and order dated judgment and award dated 1/10/2024 passed by the learned member MSCP Margarita in MSc case number 14 of 2020. Let notice be issued to the respondents. Returnable in 4 weeks. Step be taken by registered post with AD and also by legal process. List after 4 weeks.
Obliged, my lord.
Done at
Same, my lord. Same, my lord. Limitations by about 210 days, my lord. It is for the first time.
38.
Happy, your lordship. My lord, notice may go first time listed direct condonation of 136 days.
136
days.
36 days.
Sole respondent.
Heard Mr. Tekta, learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by the applicant for condonation of delay of 136 days in filing connected regular second appeal against the judgment and decree dated 25/4/2024 passed by the learned civil judge senior division number 1 Kanpur Camp in title appeal number 13/2016, by which the learned civil judge has dismissed the appeal and thereby upheld the judgment and decree dated 23rd of December 2015 passed in title suit number 30 of 2010. That notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. List after 4 weeks.
Deeply obliged.
39.
My pleasure, lordship.
This IAS for condonation delay of 13 days.
1/3.
1/3.
Let notice book.
Lordship.
Heard Mr. PJ Burman,
Yes, Lordship.
learned counsel for the applicant. This interlocutory application under section 5 of the Limitation Act is preferred by applicant, the National Insurance Company Limited, for condonation of delay of 13 days in preparing MSc appeal.
Yes.
In preparing an appeal against the judgment and award dated 13/11/2024 passed by the learned member MSCT Gulaghar in MSc case number 42 of 2013. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. List the matter after 4 weeks.
Obligation.
May it please your lordship.
Yes.
In this case, the petitioner counsel, Mr. B. Sharma, has left the court due to some emergency. Kindly matter may be adjourned for the day, my lord.
Okay. As prayed for by Miss
S. Musahari, madam.
Learned counsel appearing on behalf of Mr.
B. Sharma.
B. Sharma, learned counsel for the applicant. Let's list the matter. When? After a week?
My lord.
After a week.
Obliged.
My lord, service is complete on this phone number 1 to 4, my lord. And service may be awaited on this phone number 5, my lord. He is the owner, my lord.
May I please,
Mr.
Lord?
Mandal, you are for?
I am for 1 to 4, all the claimants respondent. Your
And
Lord,
5 is the
5 is the
Five
owner
the
cum
owner, my
driver
lord.
of the vehicle.
of
Yes,
the
my
vehicle, offending vehicle. Your Lordship, so far delay is concerned only 46 days, 46 days. Otherwise, I have no
The
objection.
other party, respondent number 5
He is the owner, my lord.
is the owner.
Yes, my
Your Lordship, even at the time of admission of the appeal, they have to take step upon the owner. So far delay is concerned, if your Lordship pleases, then
No, later on he may come and again object in filing this or no, in condoning the delay.
I leave it to your Lordship. As your
Because
Lordship pleases.
he may say that the order was passed without his knowledge, without giving him an opportunity of being heard.
First time he got.
Heard Ms. Sharma, learned counsel for the applicant, and Mr. Mandal for respondent number 1 to 4. Office note dated 19/2/2025 indicates that neither ID card nor unserved copy in respect of respondent number 5 has been received. You take press step then. Or we will await service report.
Await, my lord.
Await.
1 week, my lord. Thereafter, my lord.
List the matter after 2 weeks, awaiting service report upon respondent number 5.
Obliged, me.
They have filed a petition for direction to release 70% lordship, but we have not even deposited anything. We have a IA, we have filed.
You have not deposited anything.
No, because there is a IA lordship, lordship can take that IA also. That is, is 4030.
Hmm. So you have not deposited the 50% amount.
No, lordship, there is no direction. This IA last order was that since we have filed it, so lordship today, though their IA is at the top, but I think our stay petition has to be taken up first, because first in the stay petition, lordship will direct us.
Your stay petition is numbered as
4030 of 24.
No, your that is judgment and award has already been stayed. You see this order. Subject to this 50% deposit in the court.
I didn't go through the record lordship have been deposited. I don't know.
Not yet deposited. No.
Not yet
Not yet
deposited.
deposit.
So lordship, I'll take the instruction. I'll take the instruction means since it was not even in my yeah. Lordship may fix it after a week.
And in the meantime, you deposit the amount.
That's what lordship. Or lordship will give us 2 weeks. 2 weeks time. In the meantime, we'll deposit.
No, why 2 weeks?
Ikke jana na deposit.
1 week.
No, network no recorder. Can I just have a look at the main file?
It was first in the month of January.
Yes, sir.
Appeal to deposit. Oh, 19. No. I stand corrected, lordship. I have given them my letter to deposit.
Heard Mr. A.T. Sorkar, learned counsel for the applicant, and Ms. R.D. Mazumdar, learned counsel for the respondent.
One week, lordship.
Ms. Mazumdar submits that she may be granted 1 week time so as to enable the appellant to deposit the 50% of the awarded amount before the registry of this court. There is accordingly allowed. That is the matter on 26/3.
I'll apply to the
Obliged.
Serving at 43.
May praise your lordship. Lordship, here the petitioner has assailed the impugned order. Impugned order, lordship, at page 42.
So, Mr. Gogoi, all along from the year 2006-7 till date, the name of the petitioner is reflected in the Dias code.
My lordship.
That is right?
Yes.
And impugned order is at page number
Page 42, lordship.
42.
Lordship.
It's 40.
Page 42, down below.
Last
lordship.
part.
Lordship,
Decision.
four paragraphs from the bottom, lordship. Accordingly, SSA Assam has submitted DICE verification report in respect of the petitioner's school, in Kumalipara MEM, and as per the report furnished by SSA Assam, the name of the petitioner Mohar Ali does not appear in the DICE data of 2011-12. Now, your lordship will kindly see the findings decision. In view of the above facts, it is seen that recommended so and so. However, as the name of the petitioner could not be recommended, as his name does not appear in the DICE data of 2011-12. Now, lordship, the SSA has clarified that my name is all along there.
We will direct the education department to now verify as per our DICE data what is there in before his honorable court, and immediately, my lord, if he is the same person as reflected in the DICE data, he should be provincialized immediately. No point, my lord, keeping it.
Because the entire impugned order was passed based upon the SSA report. Now, SSA themselves have clarified that my name is all along there. Therefore, now, lordship.
No, there was no such report, my lord. In fact, in another case, my lord, we have verified there is no such report.
That is
some emails were forwarded from our office. No sign, nothing, my lord. And on that basis, all these orders were passed.
Director.
Somebody has suffered, my lord.
This is not the way, no?
Yes, no, that's not the way that it should be. And without the authority of the director and all, my lord.
The teachers are rendering their service without
yes.
any salary till the verge of their retirement, and these people are playing with this with their life. Whenever we'll pass on.
The direction will be issued to provincialize my services with effect from the date the others were done, with all consequential benefits.
Okay, in the light of this
Lordship.
affidavit, they will verify the record, and if found it is okay, then they will provincialize it.
Lordship.
Disposing of this.
Obliged.
Number one.
May I please, your lordship? Sorry to trouble your lordship because urgency has arisen due to holidays. Here, my lord. Government. No, I take it. What yes? Okay, yes.
Where is the eviction order?
My lordship will get it now. Very, it pays me, lord. Vernacular, your lordship will get in page 120, my lord. Type copies 1 that is 18, my lord. Entitled suit, my lord. Lordship got it. 120 is in vernacular original.
And when did you receive the notice?
That is on 12th, my lord. It is afternoon. It was pasted in my shop.
Then within 7 days, we have time till 19.
No, because 11, that is why, but when is this one? If we assume it 11, then it becomes today's last, the 7 days. And the 12 we count it.
No, 12 will, that has to be counted from the date of receipt of the notice.
That is 12, my lord. This is our statement only, because we are, this is pasted, because when it is pasted, we have seen only afternoon. Evening, they have given us call. That is why, my lord, we were, that's why, personally, it was not served to us. That is the case, because they may take as Betty.
Have you served copy
Yes,
upon any government document?
Yes, we have served to government. Government is there, because basically, basic cases against us here.
To whom you have served?
Government office you issue. Whenever government leaders.
No, in High Court.
High Court. High Court we have served. 13th we have filed on 13th, my lord. And fact is this, my lord, what happened? That particular day, 532 when it was issued, that date was fixed for WS filed by the dependent number 1, and it is hearing on objection petition, my lord. But morning, government pleader has come that, government submitted before the court below that now, as per provision of section 3 of Right to Fair Compensation and Transparency Act, that is RFL Act, that is 60T it is barred, civil court is barred. That is oral submission. This order itself clearly says, my lordship may peruse, because my only this one, lordship may see, order, this one, page 114, my lord, operating 113, my lordship. That is one of the vital point. Here, our High Court judgment I will refer now. 113, my lord, page, lordship got it, annexure 16, my lordship. 116, sorry, 113, annexure 16, operating portion is, my lord. Next very page, 114. Lordship got it, I think. Lordship. 114.
Yes, but this annexure 15 starts from 102.
No, here, annexure 16, my lord. Lordship, you are taking addition. Question. CRP, your lordship is taking CRP, or lordship is taking the CRP, my page number is, my lord. Lordship 113, it is not. 113, annexure 16. Impugned order.
Annexure 16 at 100 and, yes, 113. Yeah.
13, my lord. Lordship, next page, your lordship 3. Lordship got it. Both plaintiff and defendant number 2 are duly represented. Defendant 1 has appeared and filed wakalatnama for her engaged advocate, and along with petition number so and so seeking time for filing WS. Someone issued on defendant number return answered. However, as defendant number 1 has tendered her attendance before the court through engaged advocate, so there is no requirement of reissuance of any more summons on defendant number. Learned, now this is important, my lord. Learned GP of the defendant number 2, that is for district commissioner, has appeared and orally submitted that the instant suit of the plaintiff is not maintainable as against defendant number 2 due to lack of jurisdiction of court. Taking into account of the submission of learned GP, the court has gone through various provision of the Right to Fair Compensation and Transparency land acquisition, rehabilitation, and reconsideration Act 2013, Section 63 of the Act lays down provision regarding jurisdiction of the court barred. No civil court other than High Court, other than under Article 226 or 227 of the Constitution of same court shall have jurisdiction to entertain any dispute relating to any acquisition or respect which the collector of the authority is empowered or by under this Act, and no injunction shall be granted by any court in respect of any such matter. It is seen that the plaintiff in the stand.
You are appearing.
Yes, we'll give you a copy. I'm reading now. You just go through 113 page. Kindly go through. B which has 114. Then, my lord, here it is seen this a right to fair condition. It's seen that plaintiff in this instance should remedy against defendant number 2 under right to fair compensation, transparency, land acquisition, and Reconsideration Act. Thus, in view of the approach provision of law, it is found in court is barred not to try this suit is again. Here, timing, if we are assuming, my lord, before going to our citations, even this is a oral submission. This is keep on hearing. In this case, defendant number 2, that is respondent number 2 has filed WS. In WS, he has clearly said that this act is not applicable. This right to fair compensation is not applicable. But learned court, trial court had held that no, your person interested, you are interested for this. That also am not coming on. At present, today before lordship, it is clearly such an oral submission. I would have given at least one opportunity, though I prayed, opportunity to, they should give you an opportunity to give me, because this case is running for a long time. And objection today, that day was fixed for objection hearing, my lord. That day was fixed for objection hearing. That apart, my lord, before going that, I'll go by the our Honorable High Court, my lord. It was decided in 2015, Maulavi Muddaddin Jaminuddin versus reported in 2015. That was divided. Here it is, my lord. 63 will be barred. Even when it will be barred, my lord, when question of title of share, my here is title of share is question is there. Because I am being a tenant, I am as per law, that is which law they are depending. 63 section, that is right to paragraph definition 3x clearly says tenant is having personal interest. I am also entitled for share, whatever that is to be decided first. That where acquiring the land, they have to decide it first. Then after deciding only because what share allocated, thereafter, here without deciding my issue, do not going to me, they have approached, they have payment to them. That is why we have filed title suit, my lord. An injunction is there. That was keep on hearing, my lord. That was pending. Suddenly, without hearing me, that is a violation of clear and assault justice. And your lordship will 2015 to GLR, our court has, I have seen only, this is the judgment only proper, right to for commission where 62 will be applicable. Where applicable? Where question of title will be, interest will be there. Title is there. Here am I, first title is to be decided by you how much share I will get it, my lord. That is that this is maintainable. Even that will for hearing if we go, but at least, my lord, I should go for, I should get an opportunity. And apparently, my lord, what happened? After violation, then they have issued me a notice, this one for violation. And that apart, my lord, where public interest will not affected, road has already been constructed. This our only 10 feature there. There is a little drainage side, ROW. Already road has been completed, which I have stated in my, and photograph also I have given, colored photograph I have given before lordship may see page that is. Already road has been constructed. There is no debt. There is no problem here. Annexure 19, my lord, I have seen only some portion where it is left for drainage. And we are doubt, giving us opportunity here. They have clearly said, my lord, in a one way, if it is, they say, one way, this act is not applicable for you. Another hand, there, my case is dismissed against him, considering of decision. This is a crucial contradictory. I'll give you lordship may produce state to WS, my lord, even page 84. They have clearly said, paragraph 16, my lord, WS. Here, they have filed a WS that is starting from annexure 11, page 81, relevant whereas in 84, my lord. Paragraph 16 said that in content of the para 9 of the plain, the answering defendant begs to state the plaintiff is not protected under the provision of rectifier. One way they are telling, I'm not applicable for that. And when case is dismissed by the same act, that is to be also, it is why above all that, I should be at least today I am on before lordship, I should be given one opportunity to hear, so that I can place this judgment. This judgment may not be relevant, they may not consider, but I should gain an opportunity to file before a trial court that this is the judgment is there, where it will be applicable. I can say at least this much. And suddenly they are issued, and thereby road construction will not hamper, my lord. I have given a statement, and photograph also I have given. Road is already completed. And they themselves has called me, or they have called me after when I have given complaint after payment to compensation to landowner, they have called me. But one day this one landowner did not come, did not turn, and another day they have come. She confessed that I'll pay, but they did not pay. Ultimately, they are telling without getting a payment. As on that, I'm running, my lord. Today, I am also I'm filing. Last month, I have paid electricity bill, everything I have been paying. Today, I am on a probation, my lord. It's considering, my lord, protection. And as road, if road would have been construction hampered, road would have been not completed, definitely I would have, but definitely agreed. But here, road has already been completed. And then my share is to be decided only, my baby hard, my lord, at least. This was my prayer before lordship today. Mayor, they all along they were running, my lord. If I go for entire judgment, it will take time, my lord. That is why today. And if you go for addition, they then and trial court, virtually it was held that I'm entitled.
Madam, have you seen that notice dated 11th of March?
I said, আপোনাৰ কপিটো আমি ইষ্টাকে দিছো, আপোনাৰ কপিটোত চব কৰা আছে। Page number 119. আপুনি পাইছে জানো নাথাকিব পাৰে মই আপোনাক দেখুৱাইছো ৰ'ব পাইছে হেৰি নটিচ
So, madam, you do one thing. We will take up the matter on Wednesday. And till then, you ask them not to demolish the shop. Will not issue any written order, but it is the request of the court that till a decision is taken on this petition on Wednesday, you ask them not to demolish the shop.
That may be recorded in the order.
No, to record it in the order, we have to hear both the parties. We have to.
Matter. The
No,
government
no,
advocate who is dealing with bench 4 matters have to be allotted this case.
it is CRP bench 1 matter
Bench 1 matter.
it is a bench 1 matter it is your lordship is taking bench 1 matter
In the meantime, you go to the record.
Bench 1, government advocate lordship.
আপুনি গভৰ্ণমেণ্ট বেঞ্চৰ
I'm a government advocate lordship, but I'm allotted with bench 3 matters. Therefore, lordship, I
Lordship,
will
may
have
little
to
observation
hand
may
over
give
this,
me, Lord.
brief to a bench 1 government advocate. Lordship.
Who is a pension government advocate?
Right now, lordship, I was just called. That is why, lordship, I came.
lordship may little observation there is a final
Make the
notice
that
final observation only till that he wants that because
lordship may keep that in written because lordship I'll have to hand over it to somebody and oral.
Mr. C. Borua, learned counsel for the petitioner.
my lord
And Madam, your good name,
You,
please.
Sharma.
Learned counsel for the respondent. You are for respondent number 2.
2 million
Respondent number 2. This civil revision petition is referred by the petitioner against the order dated 5/3/2025 passed in PS case number 43 of 2024, as well as the order dated 5/3/2025 passed in connection with Mizze case number 72 of 2024. Passed by the learned civil judge,
senior division
senior division at Gulagat, whereby the title suit and the case were dismissed against respondent number 2. And also to set aside and was the notice dated 11/3/2025 issued by the Circle Officer Gulagat Revenue Circle. Mr. Borua, learned counsel for the petitioner, submits that after dismissal of the title suit number 43 of 2024 and Mizze case number 72 of 2024 against the respondent number 2, the circle officer, Gulagat Circle, has served one notice upon the petitioner dated 13/3/2025 for
that is my lord 11/3 that is 11
11/3/2025
my lord
for vacating the suit premises within a period of 7 days from the date of receipt of the notice And the petitioner herein has received a notice on 12/3/2025 in the afternoon.
By way of pasted in her shop.
And the same was
Notice was pasted on shop.
served by hanging a copy of the same in the wall
In the shop.
of the house of the petitioner. And that there is an urgency in staying the aforementioned notice. And otherwise, the shop of the petitioner will be demolished and it will cause irreparable loss to her. The submission of Mr. Borua needs further consideration. That is, this notice be issued to the respondents returnable on Wednesday. However, no formal notice is required to be, but you have to issue notice to the respondent number 1.
No, I'll also but stay against him only.
But how can you serve the notice upon her?
Otherwise, my lord, this is mainly injunction petition. We have prepared respondent number 2 only, my lord. Because we will be a title suit will keep on government CRP. But regarding we have filed one application also under 39 rule 1 and 2 also here this along with this, my lord, CRP.
Till 19th of March 2025, the notice dated 11/3/2025 issued by the Circle Officer Gulaga stands state. Based on 19 for further consideration.
I love like. Did you তুমি তাৰপৰা অফিচৰ পৰা লৈ ল'বা? দিছো, হয়? নাহে আকৌ এইটো নাহে